Justices of the Appellate Division Court Department, hear ye, hear ye, hear ye. All persons having business to do before this court withdraw near, give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is People versus Seymar, case 384.
Good morning, Your Honors.
Counsel, your opponent is submitted. Is that my understanding?
That is correct, Your Honor.
Very good. Proceed.
Thank you, Judge. Faris Rumi, attorney for Michael Seymar, defendant appellant. Your Honors, in this case, as the court is aware, Mr. Seymar entered a plea to criminal assault in the fourth. He received a sentence. The issue is how
Has he been resentenced?
he has, Your Honor.
And what impact, if any, does that have on this current appeal? The fact that he's been resentenced and you're here on an order that's now been superseded?
Your Honor, we filed a notice of appeal after he was resentenced.
But on this order, designating you're reset from the original sentencing, not from the second sentencing.
Your Honor, the resentencing just reiterated that he was a second felony offender. So I'd submit that it has no effect.
All right, so your position is it's not a superseding order and the appeal continues from the original order?
Yes, Your Honor.
All right, proceed.
And so, Your Honors, our issue is with how sentencing was conducted. The county court judge permitted the daughter of the decedent, Nicholas Abbott, to speak at length, to read a letter from Mr. Abbott's cousin.
And your position is that the charge itself, the tone and tenor of the letter and the comments made at sentencing were blaming your client for the death.
Yes, Your Honor.
And the charge did not. The charge that he was facing, that he was taking a plea to, did not involve that at all.
Exactly, Your Honor.
Yeah. And you said that your point is that information should never have gone before the court with respect to sentencing.
That is correct, Judge.
Should have been stricken.
Yes, Your Honor.
Okay.
And so our issue is,
If there was actually a murder charge or manslaughter charge, where it might have been here, would it have been appropriate for the individual to make that victim impact statement?
it would be if my client had been convicted of one of those
Right,
charges.
exactly. That's my question.
Yes, Your Honor.
Okay. So in this instance, because it was criminal possession of controlled substance or it's criminal sale, it didn't involve the murder or manslaughter or whatever.
That is correct, Judge.
And you're saying your argument is amplified by the inmate saying that the decedent died of natural causes.
That is correct, Your Honor. And further, as the court is aware, that the people cite two First Department cases which are not binding on this court. And our position is that neither are on point, because in both of those cases, the decedent, their death was either caused by the defendant or part of the interaction with the defendant, which is not the case here. Second, the Rivers case cited does violate the legal doctrine of expressio unis et exclusio alterius, as I explained in my reply brief. As the Court of Appeals has written, an irrefutable inference must be drawn when what is omitted or not included was that it was intended to be admitted or excluded. The CPL is clear that the victim can speak at sentencing or their family member or guardian. It does not mention at all someone who's not a victim. So for those reasons, our position that it was improper for county court to permit these submissions and statements. It was improper for them to county court to factor that into my client's sentence. And it was also improper for county court to issue the order of protection in favor of the widow of the decedent.
I think we have your argument, counsel.
I'm sorry.
We have your argument.
Thank you, Your Honor. In that case, on the remaining issue of the harsh and excessive sentence, I rely on my brief.
We'll take that into consideration. Counsel, thank you.
Thank you.
Case number 386, People versus Jones. Proceed, counsel.
Morning, Your Honor. Stephanie Stair for Mr. Jones. I'm going to concentrate today on points 2, 3, and 5. The evidence at trial was against, I'm sorry, the verdict at trial was against the weight of evidence on counts 1, 2, and 3. The body worn camera in this case is very illustrative of the lack of proof. I trust that the court has viewed that. The biggest missing elements are there was no intent shown. The evidence presented illustrated that Mr. Jones' mental condition prevented him from forming the necessary intent. His mother, Caraba's employees, customers all testified to him not being in full control of his faculties.
Was there any professional opinion about his mental state?
There was not, Your Honor. However, I think it's notable that both people who have known him his entire life and people who didn't know him from Adam testified that he was clearly struggling and clearly out of his mind that day. His mother, his boss, and then the employees and the customers in Caraba's.
Was there any request at any time by his counsel to have his client examined, for mental stability?
I believe there was. It's not in the record.
Okay.
I obviously know more than is in the record, but it was not presented at trial from a professional standpoint, like you said.
In the surveillance video, a couple things that were surprising. First of all, the staff that was there in the restaurant and the Carrabba's appeared to be sort of unfazed by this, even as the officers were coming in.
Yeah.
They were working, cooking food and preparing. The room where the defendant was, the dining room where the defendant was with the bar, that looks like it had been cleared. I didn't see any customers sitting in there, correct?
The officers, at the same time that Deputy Hamzik and Deputy Wegman are interacting with Mr. Jones, other officers are working on clearing the dining room.
So that may be happening off camera.
It's happening off camera, exactly.
All right.
But it's happening sort of simultaneously. But there were still some people in the dining room when the shots were fired.
That's it.
Also, an intoxication instruction was given to the jury. Almost all the witnesses testified to a heavy smell of marijuana, and obviously he's seen chugging alcohol behind the bar. The other element I think that is lacking is that there was no proof of Mr. Jones's knowledge of Deputy Cooper, his status as a law enforcement officer. So Deputy Hamzik and Mr. Jones are interacting. Deputy Hamzik is clearly recognized him as a man in crisis, not a threat, doesn't have his weapon drawn. They're talking calmly. And then Deputy Cooper comes in from the opposite direction, basically charging at him with his gun discharged. And then Mr. Jones's gun and Deputy Cooper's gun go off simultaneously. He never identifies himself as law enforcement, and there's no evidence that Alonzo knew in that split second that he was a law enforcement officer. In fact, it was shown that he was still suffering from delusions of being chased. And then this other person comes at him. The only other thing that I want to highlight.
Bother you one more second. So with regard to the defendant's mental status and with regard to his status of being intoxicated or under the influence, did we have any professional testimony in this trial about either of those two things?
We don't. And that's something I was going to bring up in just a moment. The police collect the blunts that were on Mr. Jones, the one that he was smoking actively in the building and the ones he had on his person. There's also some pills that come out when he gets pat frisked. All of that is collected, taken into evidence, and no one ever tests it. So it was outside of the defense counsel's ability to have it tested, and the people didn't do anything with it.
Right. It's sort of a double-edged sword.
Yeah. Yeah. The only other thing that I want to highlight, I know we don't like to drone on about facts. However, all of the anti-police sentiments attributed to Mr. Jones at trial were shown to have been stated for the first time at the trial. The hostess testified that that Mr. Jones said if the cops come, he'd shoot them. He'd be ready if the cops showed up. But what she said to the law enforcement right after it happened was that he just said he had to be ready. Another employee testified that Mr. Jones said he had a gun, and if he saw the cops, he was shooting. However, on that evening, all she said was someone was following him and he didn't want to hurt anyone. And then the server testified that he said, don't call the cops because that's when things will get crazy. But what she told the cops that night was that he said, I'm chilling, please don't call the cops. Those are really, really different statements. And the only time that any sort of anti-police threat or sentiment comes to light is at trial. And the defense counsel did a beautiful job of impeaching the witnesses and showing that those statements were being told for the first time at trial. No one ever said anything to the cops at the scene, though no one ever put that in their written statements. And I think that that's a really important point to consider in a weight of evidence analysis.
You want to get to the harsh and excessive before your time runs out?
I do, Judge. I also briefly want to touch on point 3, the trigger lock removal. This is kind of a case of first impression because the case law deals mostly with a defense attorney coming up here saying demonstrative evidence was put in against my client over my objection. We're saying the opposite. We wanted it in and the court didn't allow it. The accidental engagement of the trigger was part of the defense strategy, and it was an abuse of discretion to deny that request.
But wasn't there testimony, and I may have this wrong, you know the record better than I. Wasn't there testimony from an expert about the ability to pull the trigger and the difficulty of pulling the trigger, the pressure needed and that kind of thing? In other words, without the demonstration, there was still some testimony, and the judge's ruling to not let that demonstration happen was done just based upon a safety concern.
You're correct. Your Honor, there was testimony that it took 3 to 4 pounds of pressure to pull the revolver trigger as opposed to, I think it's 7 or 8 for a police officer weapon. But the safety concern, when you have an expert on the stand, they are an expert, right? They can secure the gun. They can assure that it's not going to go off. It's unloaded. It's a revolver, so you can clearly see if it's loaded or not. And the only safety concern would be if they're going to, chuck it at each other, right? Like it can't accidentally go off.
Alec Baldwin, and a director of a movie, might disagree with you.
Correct.
Right?
Yeah.
I mean, things happen.
Absolutely.
Precautions are taken.
Absolutely.
And the judge in this case wanted to make absolutely sure that nobody was injured. And that is a concern, correct?
Absolutely.
Yeah.
Absolutely. I would point out that juries have been allowed to test fire, but not play with the gun. That's a terrible way to say it, but
Right. No.
manipulate the gun.
Right.
This court actually in Andrew found that was violated the defendant's right to confrontation because that was done outside of consulting him. It just happened. They sent it back to the jury. We're asking the opposite. We're saying it should have happened. So this court's ruling in Andrew, I would say, is completely opposite of what we were asking
We'll
for.
take a look at that.
Thank you. And then very briefly, so sorry. The harsh and severe,
What was the sentence? 40 to life?
40 to life, which is his maximum.
No one was injured.
No one was injured. The point that is really bothering me at this point, the DA asked for 30 to life. The minimum is 20. DA asked for 30 to life. The judge who sentenced him was not the judge who sat through the trial. That judge only performed the persistent felony offender hearing.
I didn't get that. Only what?
She only did the persistent felony offender hearing.
Yes, thank you. Okay.
The judge who sat through the trial was no longer available, so it was transferred to Judge Hahn.
Mm-hmm.
So having not sat through the trial, having, I would guess, a level of unfamiliarity with the facts as opposed to the prosecutor who prosecuted the case and lived with the facts for years, went above and beyond what even that prosecutor was asking for. I think that's harsh and severe.
We're going to take that into consideration.
Thank you. If there are no other questions, I would rest on it.
No other questions.
Thank
Thank you,
you.
Counsel.
Good morning, Amy Wolensack on behalf of the people. Excuse me. I will address the same points as counsel unless the court had any other questions about the remaining points. Excuse me. With respect to the verdict, I believe that the verdict here was supported by the weight of the evidence. Specifically with respect to defendant's intent, he pointed this gun and fired it and missed Deputy Cooper's head by under 3 feet. And I would also note that with the innocent patrons that were sitting in that booth, it's by my count from Deputy Cooper's body-worn camera footage, it was 5 seconds between when they stood up and left and when that bullet ultimately went into the wall right above one of the patrons' head. I don't think there can really be any dispute about what defendant intended to do when he fired that weapon. I also note that with
Does it matter that the witnesses that did testify indicated that he was going through some type of emotional, psychological episode at the time all this unfolded?
I would agree that my recollection of the testimony, and forgive me, I did not prepare the brief, so
Looking at the video demonstrated that too. So I mean, in Exhibit 3.
If I believe that what they testified to was that he didn't seem fully with it. I don't think there was anything, they didn't testify or opine that he was in such a state that he couldn't comprehend the nature of his actions.
Well, they really, I mean, I don't even know if that question was asked, whether it'd be allowed to be answered, right? I mean, they testified as to what they saw, right? Not some psychological expert opinion. But what they saw is important.
Yes, but I also think that what's demonstrated on the body-worn camera footage at different times, the defendant is conversing with, I believe it's Deputy Hamzik, and it is clearly with it enough to be complying with his commands and understand what the officer is asking him to do, and conversing at times with him. So I don't think that it rose to such a point that he was unable to comprehend the nature of pulling the trigger on that gun. And with respect to the trigger as well, this wasn't a double action revolver where the accidental pulling of the trigger would have discharged it. There were 2 actions that were needed to discharge this weapon. He had to fully cock back that hammer and then pull the trigger. So there are steps here. This was not a single impulsive action. He had to take multiple steps in order to pull that trigger. And I would respectfully disagree with counsel that there was insufficient evidence to show that he knew that he was firing at a police officer. I believe it's in Deputy Hamzik's body-worn camera footage. You can see at which point Deputy Cooper and I believe one of the other officers walk by the windows there. And I believe it was Deputy Cooper who testified they were mirrored. So the people inside of the restaurant could see out, but those on the outside could not easily see in. You can see the point at which defendant turns and clearly recognizes that there are people walking in, and Deputy Cooper was in full uniform, readily identifiable as police. I think not only do I think defendant recognized him as a police officer based upon what was captured on the footage, but I think any reasonable person would have realized they were firing at a police officer. And then I briefly, with respect to the trigger lock, Presiding Justice Lynn, I completely agree. There is a safety concern when you are asking to pull the trigger on a gun in an open courtroom. I don't think it was an abuse of discretion for the court to decide that that presented too great of a safety risk. This was a courtroom, not a firing range. And with respect to the sentence, I did want to briefly.
It is the maximum, right?
It is the maximum, Your Honor.
Right. Yeah, and nobody was hurt, although, as you point out, a bullet was discharged and.
It was by the grace of God, and I think we were 5 seconds away from. Yeah, I believe it was Thomas Doyle who was standing up, and I think that we can readily infer that if he had stood up 5 seconds later, he may not be here today. Mm-hmm. I do want to clarify the record, though. The prosecutor didn't ask for 30 to life. My read of the record was the prosecutor asked for at least 30 and somewhere closer to the maximum of 40 years. So I would just like to clarify what the request actually was. Mm-hmm. This was the maximum sentence. I recognize that, but I do think that the conduct here presented a grave risk to the community. This was just a run-of-the-mill Thursday night, a summer evening. There are how many patrons that are being escorted out of this restaurant that I believe one of the patrons testified she was very scared while the defendant was in there, felt something was not quite right. And she was terrified at one point that her husband had been shot.
Counsel, remind me with this defendant in the record, what evidence is there of any prior felony offense?
So I know that there was the persistent felony offender hearing. I know he was adjudicated a second violent felony offender for counts 2 through 4. I apologize. I don't recall the exact felony convictions. I believe one of them may have been a robbery, but there was a guilty plea involved in that. And that was what ultimately led the court to deny the persistent felony offender status. But again, while nobody was hurt, I think it's by sheer luck that happened. All of the patrons that went out expecting to just have a normal dinner at a restaurant deserved to do that without being put in fear of dying that night. And the officer,
On Deputy Hamzick's body cam video, it looked, seconds before the shooting, 5-10 seconds. The defendant had moved out from behind the bar, had his hands up, is conversing with Deputy Hamzick. Looks like it's progressing to the point where it's going to be okay. And then I think Deputy Hamzick said something about his father.
yes, I believe.
That's when it changed rather quickly, suddenly, and then he goes back behind the bar, picks up the gun, shoots it once, down the shots, and then it's over. But this whole sequence before when it looked like he's engaging with Deputy Hamzick, I mean, isn't that something that's a bit of a mitigating factor for the defendant? If it doesn't, necessarily say, well, he didn't form the intent, if we don't go there or say it's accidental, but isn't it still a mitigating factor for sentencing?
I think it would have been a mitigating factor if he had carried through, because I think that demonstrates at a point he was willing to, but then he made that choice to, as Your Honor pointed out, step back behind the bar, pick the gun up, and again had to take those 2 steps to actually fire it. There was a way for this to end peacefully, but it's because of the defendant's actions that it didn't. He ultimately is the person that chose to pick up the gun and fire it. And I don't think the danger to Deputy Cooper can really be understated. I mean, this bullet missed him by less than 3 feet. If that had hit his head, we would not be here on an attempted aggravated, we would be here on a full-on aggravated murder. I think that the judge that conducted the sentencing, she had never given any indication that she would have been willing to accept the offer that was extended before trial. And I think she rather
wasn't bound by that.
No, she was not bound by that. And I think she rather eloquently stated why she felt that the maximum was warranted in this case. And I would ask the court to affirm the conviction and the sentence in full. And unless the panel has any other questions, I'll rest.
Thank you, Counsel. Case 387, People versus Post.
Daniel Guard, on behalf of the people of the state of New York, Your Honor, represent the respondent.
Very good. Thank you, Counsel. We're going to wait for your opponent. There we go. Counsel, can you hear us?
Your Honors, Matthew Shooting for the appellant, Dustin Post.
We can hear you, and I assume you can hear us.
Yes, Your Honor.
Proceed.
Yeah, good morning, Your Honors. My name is Matthew Shooting. I represent the appellant. I'm going to keep it brief. I don't want to belabor the record. There's just a couple points from my brief that I would like to touch on a little bit. First, just with regard to the consent and statements obtained during the November 15th, 2019 interview at the defendant's home. Your Honors, it's our position that under the totality of the circumstances, even if the defendant was not literally in custody, he was functionally and de facto in custody. 2 plainclothes officers showed up at his home unannounced, interviewed him for over 1 hour with accusatory focused questions in a partially enclosed area. It was the middle of November. It was cold outside. He functionally was not free to leave when the only option was to leave his own home. And I believe he was not able to drive. So to just walk away from his home in the middle of November.
But he was permitted to go into his house, into his bedroom to retrieve various items for the police, and that he suggested that he had in the residence, which were related to the questions that they were asking.
Sure, I'll acknowledge that point, Your Honor. However, he was not free to leave the interview.
He wasn't arrested. He wasn't arrested at that time. He wasn't arrested at that time either, right?
That's correct, Your Honor. He was not arrested at that time, but that
and he agreed to meet for a polygraph later. I mean, he was very, attentive.
Yeah, and yes, Your Honor, that brings me to my next point.
No time did he.
And that brings me to my next point. He agreed to meet for the polygraph while he was being driven to work in a vehicle by the 2 officers alone with them. That was certainly a situation that he was not free to leave. And if Your Honors have no more questions regarding that issue, I'll move on to the second set of points in my brief, which is the Molyneux Ventimiglia issue. Your Honors, the admission of the prior bad acts, including the what turned out to be a very graphic account of sexual contact with a victim who was not named in the indictment, along with discussions of his possession of child pornography, a charge which also was not included in the indictment. None of that had anything to do with any motive, intent, or common scheme. And even, assuming for the sake of argument that its admission sought by the people was not a pretext to add prejudice into proceedings, that was the effect that it had. None of that had anything to do with establishing a background. And even to the extent that it did, its effect was so prejudicial to cast the defendant as morally repugnant in a case that already had a lot of emotions and
Are you speaking about, excuse me, Counselor, are you speaking about all the incidents on the polygraph exam, or just the ones that weren't related to the victims?
Just the ones that were not related to the victims, Your Honor. I apologize for not being more
That's all
clear
right.
about that.
It just seemed to be a general argument, and I just wanted to make sure that we're limiting to those instances that you're talking about where they weren't related to the victims. But in those instances, couldn't you argue that was waived because of the fact that these tapes were given to the defense counsel beforehand? He had the chance to review them beforehand. He had no objection that was registered before then, except during the time of trial when those were revealed. So,
well, the objection was preserved for the record at trial.
I understand that, but again, all those that instance that he's objecting to, he could have made that concern made available to the district attorney or to the court themselves, as far as this item should have been redacted because it was not related to one of the victims. Herein.
I will acknowledge that point, Your Honor. However, it's effect at trial, even with the limiting instruction. I mean, the trial court saw fit to issue a limiting instruction afterwards, which I think is very significant to the prejudicial effect that it ultimately had upon the jury, Your Honor.
Well, aren't the limiting instructions presumed to believe that the jury is going to follow those limiting instructions?
Sure, Your Honor, but my position would be that in this case, the content that was admitted prior to the limiting instructions was so graphic and so egregious that there was simply no way to unring that bell, even with a limiting instruction.
Okay, I understand that.
Anything further, counsel?
Unless Your Honors have further questions, I'll rest
counsel.
of my papers. Thank you, Your Honor.
May it please the court. The court's obviously familiar with the people's papers and the facts of this case. So I would be happy to entertain any questions that the court might have on the issues.
The court seemed to express some frustration when the videos were shown and there were portions that weren't redacted and arguments made after the fact. And the court said, no one came before, said there's portions that aren't interwoven. Everyone here had a responsibility to look at the photos. That the court gave a little bit of a dressing down to the attorneys, including defendant's attorney, but then didn't grant the mistrial and went with the limiting instructions instead. Why was that appropriate?
Well, Your Honor, I feel that it was inappropriate, would have been inappropriate to grant a mistrial because the proper procedures will follow. In terms of that particular issue, the people had filed the motion to limine pre-trial. That issue was discussed. There was a hearing. While neither side weighed in on the limiting instructions, the people had presented their arguments in the papers. If there was a limiting instruction issue, it should have come from the defendant. The record does indicate that the defense was given ample opportunity and they submitted no proposed instructions, Your Honor.
Any further, counsel?
No, Your Honor. If you have no more questions, I rest.
Thank you.
Thank you.
Case 389 in the matter of Andre Beal versus Jackson.
Good morning.
Counsel, you're unopposed this morning, is that right?
I'm sorry?
You're unopposed this morning.
Yes,
right?
I've been opposed.
Very good. Proceed.
There's all kinds of factors that go into consideration when you determine custody. But the overarching principle of this case is that if you're a danger to your child, then you shouldn't have custody. It's really that simple. Also, I mean, he relapses.
You represent the mother.
Right.
Okay, and this is a case where the mother gave the children to the father while she went to find herself, improve her life, etc.
Exactly.
Okay, so it wasn't really the court that gave the children to somebody who was known to be alcohol abuser. It was your client who did that. Put the children in his hands.
Initially,
Okay.
but the issue was raised at trial.
Not only initially, but for an undetermined period of time. There was no set time. It wasn't that she was going out of state for 2 weeks and I'll be back, or 3 weeks, or whatever. It seems, at least, and correct me if I'm wrong, her journey that she was taking there was no end time designated where he knew she was coming back.
That's correct.
Yeah. Okay.
And her plans never gelled. She never really got work. She never really was able to establish her own business.
She never moved. She's still in Syracuse.
Didn't she go to Louisiana for a while?
Right, exactly. And then she came back and she stayed.
And
She stayed.
not only did she give the children here to the father, but also he's raising her 13-year-old child from another relationship, correct?
Correct.
And she had no qualms with giving the father custody to a child that was not his biological child.
No.
The record seems to indicate also that the alcohol difficulties that the husband's experience is also something he appears to be addressing. Although admittedly, the record reveals that he does, I think the phrase was fall off the wagon periodically.
Correct.
So we have that right?
Correct.
Yeah. Okay. Anything further, Counsel?
No, that's all I have.
Has your client brought any petitions since the date of the trial? The trial was February 24. We're now 2 years, 2 months later. I mean, if something happened.
Nothing I know of. I haven't talked to her in a couple of months, but as of 2 months ago, no.
I think we have your argument, Counsel.
Thank you.
Thank you.
Case 390 in the matter of Syracuse University versus the City of Syracuse.
Thank you. May it please the court, Zach Shaw on behalf.
Counsel, you are also unopposed, I understand, today?
That is correct.
Okay, very good. Proceed.
So we're here because the City of Syracuse stripped the tax exemption that our student unions, food court and campus store have had since 1985, based on one 45 to 75-minute visit when school wasn't in session and the assessor spoke to no one. Then the trial court below denied us our day in court based on section 525 of the real property tax law, which authorizes boards of review to dismiss grievances when taxpayers willfully neglect or refuse to answer questions. I'm going to try to just briefly touch on each of our three points on appeal. So point one, section 525 should not even have been on the table for sort of two.
The court addressed that sua sponte, didn't they?
They did. And, one of our arguments is the city could not have been more unequivocal in waiving this point below. They said they were not willing to dismiss based on 525. And the only way that a court could nonetheless reach this issue is if it went to subject matter jurisdiction, which
your argument is it doesn't.
It doesn't. We think that's clear.
So it should never have gotten there.
That's right. And then the other reason the court should not have gotten to section 525 is because the board did not invoke this section below. Instead, it denied our grievance on the merits. And again, the law is quite clear that when that's so, the court cannot invoke this provision for the first time on judicial review. And the city actually agrees with that legal rule. And then on the record, you just look at the grievances, they say denied, not dismissed. The bylaws say a denial for insufficient evidence is not a dismissal for, under 525. And then if you look at the affidavit the assessor put in below, he actually characterizes the grievance as having been denied, not dismissed.
Counsel, let me ask, let's get to the argument with under the 420A RPTL, where we're talking about the exclusively language and how the Court of Appeals interprets exclusively, right?
Yeah.
And whether or not it was being used exclusively, which, when you look at the Court of Appeals decisions in Brookdale, it's, principally or primarily is how exclusively I think is being interpreted there. You can correct me if I'm wrong. And your argument is that it really is being exclusively used by the University of Syracuse here.
Yeah, that's right. So, the statute says exclusively. The Court of Appeals for decades and decades, including in Brookdale, has glossed this as, primarily used to further hear the educational purpose. We have cited like a mountain of case law holding that like these sorts of activities, dining, housing, and the like, are reasonably incidental to the educational mission. Indeed, they are core to it, including, specifically with respect to dining halls in the Pace College case. And, really what we have here is exactly what the Court of Appeals.
If we removed the use of this facility, if we took the students' use of it out, could it exist?
It could not exist. And, I think to put the same point the other way, like we do what we do at the Shine Student Center, like in order to serve the campus community. So if you walk in, what you'll find is students lounging around and studying. And, we've got the food court there because like you're a college student and that's going on and somebody's gonna get the munchies. And, the city's submission is, well, when that happens, someone should like go off campus, maybe take, and like they say this in their brief, public transit to go find food. And like, if that was the world you're living in, the Shine Student Center would serve its purpose as a campus hub, like much less well. And, that too is reinforced by the quantitative and undisputed evidence we put in the record below about who actually uses this building. So we did a double-blind intercept survey, which showed that 99+% of the people who actually were in the building, and not just in the building, but at these specific locations at the food court and campus store, were somehow affiliated with the university. The city has a sort of different test they prefer, looking narrowly only at students, faculty, and staff. So like excluding prospective students and these sorts of things. And even taking that, it's 95%. And then—
Counsel, let me ask you this. When the students aren't at campus, let's say during the summer, how used is the facility?
So the answer is very little. You can eyeball this by looking at the chart at page 15 of our brief that goes through sort of month by month. And if you put like the 2 summer months together and look at the number of sales or the amount of sales at the student center, it's like 15% of what sales would be in like a single academic year month. Or another way to put it is it's something like 2% of annual sales. And the Intercept survey actually showed that if you limit your sort of definition to people who purchased, it's like 99.3% of purchasers are associated with the university. And so, that I think sort of puts paid to the main arguments that the city made below in terms of why, this did not qualify for the exemption. So they say, well, there's public access here, on the law, there's no such, we are not required to like shut our doors to keep our exemption. The shrine of Our Lady of Martyrs case makes that clear. And on the facts, it's just absurd, right? Like our other dining facilities are open to the public. So is our library. And the idea that we did this renovation, we had
something about an art center also that's open to the public.
The arts, exactly. That is the university's approach. And then, so their second sort of big idea is, well, you have more franchises now than you had before. And so, that costs you your exemption. That on the law runs them straight into Pace College. That is a case from the 50s, but like it is exactly this issue where the assessor came in and they had hired, a company to run their cafeteria that was trendy in the 50s. And the assessor said, well, you've now lost your exemption. And what the Court of Appeals said is what matters is what activity are you engaged in, not sort of what form of business organization have you used?
And doesn't the record
And-
reflect in this particular case, the franchises that I brought in, they're still being operated by students and employees of the university. They're not, you don't have a franchisor coming in on campus, opening up and independently running that franchise business.
No, that's right. I mean, we the way the franchises work at bottom is we pay these companies so that we can prepare their food because it is more desirable food and sort of better creates the community that we are trying to foster. And, you know, the city, I don't think genuinely believes that this alone would get rid of an exemption because we've had Dunkin' Donuts on the premises since 1995 and no one thought that made a difference. And then their sort of last big idea is that we are somehow competing with businesses on Marshall Street a couple blocks away. But sort of two things about that, like, if what they are saying is that it is a problem that the Shine Center keeps students like on campus and able to study and interact together instead of having to like fan forth into the city, like that is the center doing its job. And if what they mean is we are trying to get business from people with no affiliation with the university, there's just zero evidence that we are trying to do that. And ample evidence that in fact that is not happening, as reflected in the fact, again, that 99.3% of the people who actually buy at the student center are affiliated with the university.
The remedy that you're asking us to grant you.
So we are sort of twofold. To start, reversal of the motion to dismiss, but we'd also ask the court to direct entry of summary judgment in our favor.
We'll consider that. Thank you, counsel. Case 391, Thirsten versus Howard. Proceed, counsel.
Thank you. Good morning. May it please the court, Kirsty Means of Lipis Mathias on behalf of defendants appellants. This is an appeal of a jury trial resulting in a judgment associated with damages for past and future pain and suffering and past and future lost wages following a motor vehicle accident. The circumstances of the accident, which involve a police officer engaged in an emergency operation, implicate the first question that we've raised on appeal, which is whether the trial court erred in failing to apply the reckless disregard standard afforded under Vehicle and Traffic Law 1104 on the basis.
Was the emergency operation obvious right from the beginning on this?
We maintain it was, yes. The police officer committed an illegal U-turn in the pursuit of another driver who had run a red light.
As far as the officer's intent, was that clear? I mean, with the flashers on or the sirens or anything like that?
The flashers and lights were not illuminated, no.
So how would the person on the bus know what the officer was thinking when he cut in front of the bus?
I don't know that he would necessarily know what he was thinking, but the nature of the U-turn would have indicated that he was engaged in an emergency operation. Shortly through discovery responses and the nature of the questioning directed by plaintiff's counsel to Deputy Kent also confirmed that plaintiff's counsel was well aware that he was engaged in an emergency operation at the time of the collision.
Is your quality immunity position, wouldn't that be an affirmative defense that has to be pled and it wasn't here?
We submit that under this court's precedent in Wilson versus State, which held that Vehicle and Traffic Law 1103 need not be pleaded, that the same rationale should apply, and Vehicle and Traffic Law 1104 should also not need to be pleaded as an affirmative defense.
However, the court took away your ability to go forward on 1104 as a result of a discovery problem that it perceived. Okay, that there were documents that were sought by the sheriff's office that would have had shed some light on the viability of the 1104 defense. And so that privilege to raise 1104 was taken away as a discovery sanction. is my reading of the record.
Subsequently, the court did impose somewhat in dicta a preclusion remedy based on the belated production of materials responsive to a subpoena served for internal policies. Those policies we maintain are not dispositive of the applicability of Vehicle and Traffic Law 1104. Plaintiff had requested those by the subpoena 7 days before the trial was initially set to proceed. He ended up obtaining them 3 weeks before the trial went forward. So to the extent the court found that there was prejudice associated with the delayed production, we think that the record is clear that there was no actual prejudice.
I think the court was discussing the fact that the production of the documents came at such a time that the plaintiff was deprived of the opportunity to make a dispositive motion.
We maintain that a dispositive motion in this instance would have ultimately been unsuccessful. And ultimately, the jury wouldn't have been charged on the reckless disregard or the negligence standard until the close of proof. If plaintiff maintained that we couldn't establish VTL 1104 as a matter of law, they could have moved for a directed verdict at the close of proof, and that, in our view, would have been.
So in other words, you're saying that the plaintiff would have and should have had to put on their entire case, including, paying for witnesses. My understanding was there was several medical witnesses that were certainly not inexpensive, and you think that that would have been a more appropriate time than making a motion, in the regular course of the litigation, which would have been maybe 60 days before the trial.
I think if they had pressed to move on VTL 1104 pretrial as a summary judgment type motion, I think that the court could have entertained that, but the proof came in as it did. This is a motor vehicle accident. It's relatively straightforward. The proof was going to come in as it would. So I think that they could have made their directed verdict motion to dismiss the defense if they deemed it inapplicable. And just to briefly touch on respondents' argument in opposition to the requirement to plead it as an affirmative defense, they primarily rely on this court's decision in Torres Cummings versus Niagara Falls Police Department. That case is silent on whether VTL 1104 needs to be pleaded as an affirmative defense. So we dispute respondents' contention to the merits of our argument.
Well, do you think that the court was aware during the entire litigation that it was your position that 1104 applied? I mean, I see just in my view of the record, there were several statements made by defense counsel. The standard of care is negligence. We're guided by the Vehicle and Traffic Law, blah, blah, blah. That was at page 3911 to 3912 of the record. Again, at the next page, this is a standard negligence case. So I guess what I'm saying is you have an unpleaded defense, and then you seem to have a strategy that doesn't include pleading and proving, what you need to invoke 1104. And then you're sort of telling us that we should wait till the end of the litigation and ask for the court would have made a directed verdict at that point instead of addressing a summary judgment motion at an earlier time that would have framed the issues for the trial.
The excerpts relied on relative to advocating for a negligence or suggesting that at one point we were advocating for a negligence standard. So we've set forth in our reply, those are taken out of context. Conceitedly, I think that they could have been articulated better, but at all times we were defending and advocating for the applicability of VTL 1104 and the reckless disregard standard. The specific oral argument was relative to defending the sanctions motion that was seeking to strike our answer for failing to produce the materials. The advocacy on behalf of the county was associated with confirming that those policies are ultimately irrelevant to the applicable standard.
The policies of the sheriff's department, which would talk about when you should put your lights and sirens on when you decide to take advantage of 1104 and disregard some of the traffic rules. Maybe when, I'm just imagining from other cases, we've had issues where you need to call that in before you start your pursuit and things of that nature. I don't know what was actually in the policies and procedures, but they usually do talk about when an officer can and should, make this pursuit in disregard of the vehicle and traffic law.
Yes, and not, I suppose, entirely irrelevant to considering the reckless disregard standard, but those internal policies would not determine the application of BTL 1104 is our position. So while they could introduce those and plaintiff was ultimately afforded the opportunity to introduce those internal policies, it should not determine the ultimate issue of whether the statute applies as a matter of law.
So instead of striking your answer, the court fashioned a compromise and says, listen, I'm not going to strike your answer, but I'm not going to let you prove up 1104.
Correct, but ultimately premised on the initial preclusion ruling based on the alleged failure to raise it as an affirmative defense. And we maintain that to the extent it was premised on a discovery sanction, that it was an abuse of discretion because it was not ultimately prejudicial and plaintiff ultimately obtained the materials and was able to rely upon them.
I try.
Counsel, you should begin to wrap up.
In our second and third issues raised on appeal, I'd like to highlight two issues relative to certain evidentiary errors and components of the jury's award. They're both related to the components of the award relative to past and future lost wages. As we've set forth in our papers, these are related issues. They collectively establish that at a minimum, the jury's awards for past and future lost wages should be set aside and vacated due to the lack of reasonable certainty to sustain the amounts.
Counsel, these arguments are in your brief?
Correct, Your Honor.
Yep, your time is expired.
Thank you.
Thank you. We'll consider those arguments.
Good morning, Your Honors. John Collins on behalf of Christopher Thirsten. The judgment in Mr. Thirsten's favor should be affirmed. Supreme Court, I submit, did not err in any of its pretrial, trial, or post-trial rulings. And I note significantly defendants do not dispute that the jury's findings that plaintiff sustained serious injuries under the no-fault law is supported by the trial proof. Contrary to defendants' argument that they do make, the jury's monetary awards for future pain and suffering, past and future lost earnings are likewise supported by the trial proof and don't deviate from what would be reasonable compensation. As to the principal issue here, which is the supposed application of vehicle and traffic law section 1104, the jury selection, as the court is aware, in this case was scheduled for February 22 of 2023. At that point, defendants, for the first time, not having alleged it as an affirmative defense, raised section 1104 on the morning of jury selection. The court at that point correctly held that it could not be asserted unless it had been pled as an affirmative defense. I note that under CPLR 3018A, an answer must raise such a defense, a matter which, if not pleaded, would likely take the adverse party by surprise. Here, plaintiff did not allege in his complaint, and I submit had no reason to, that Deputy Kent was involved in an emergency operation or that he had acted in disregard of a vehicle and traffic law provision among those identified in section 1104.
Counsel, the opposing argument that was just made by your opponent just a minute ago that it was evident that plaintiff's counsel was aware of that based on the questioning at the deposition. Was that raised to the trial court below? Was that raised at that time as a basis for why it didn't need to be pled?
I don't think that was raised at that time, Your Honor. And also I note that a complaint obviously is drafted long before depositions take place. And, the affirmative defense is interposed, if it is interposed at all, long before depositions take place. It was at that juncture that the defendants could have and should have raised the affirmative defense. And I think it's not, relevant or controlling to say that, well, in the course of pretrial proceedings, plaintiffs should have realized that we're relying upon this when there was no indication in the form of a formal pleading or, even a motion that the defendants were going to rely on 1104.
Practically, does it change the course of discovery? Does it matter?
I mean, if it, I think it would matter in terms of, what is being sought, how hard it's being sought for. Yes. And I submit that defendants' reliance upon Wilson v. State for the proposition that 1104 need not be pled as an affirmative defense is misplaced, because that case involved vehicle and traffic law 1103. And as the Court of Appeals affirming this court recognized in Caber versus County of Monroe, 1104 is materially distinct from 1103 because 1103 is basically very comprehensive and broadly applies anytime a work type vehicle is on the road doing something, whereas 1104 provides what is a qualified privilege that is very fact dependent. And it's the defendant's knowledge of those facts that could have and should have prompted it to raise the affirmative defense. But I note that, even if this court were thinking that, well, it need not be pled as an affirmative defense, what's critical here is that after that initial jury selection date of February 2022, defendant moved to strike the note of issue. Discovery was held. 9 months went by before the trial was held. In that 9-month period, defendants could readily have moved to amend their answer, and they did not do so. To the contrary, as Justice Bannister alluded, finally in November of 2023, as we were approaching the trial date, and plaintiff made a motion to either strike the answer or preclude reliance upon 1104 due to discovery or failure to comply with the court's subpoena. In response to that motion, defendants stated on the record, the standard of care is negligence. We are guided by the vehicle and traffic law. It's not like we've got our own set of rules because we're the Erie County Sheriff's Department versus what a typical motorist would have driving a vehicle. Our internal policies are irrelevant because we didn't amend our answer. We're in the same position that we were last time. That can mean only one thing. It's a concession that, yes, we knew, according to the court's view, that we should have pled 1104 as affirmative defense. We haven't done so. We knowingly didn't do so. We're proceeding on a negligence standard, the same as would apply to any. And beyond those two reasons, another reason, as the court also recognized here, is that the trial judge also said it's really superfluous, but I would also preclude your reliance upon vehicle and traffic law 1104 because you belatedly complied with my March subpoenas. It didn't comply until November. So for those three reasons, really, failure to plead, a concession on the record, and the discovery subpoena noncompliance. The court certainly didn't abuse its discretion in saying, this is not an 1104 case. You're not going to rely on it. It's not going to be a jury question. And briefly, because that was all really that was addressed primarily in the argument here, but I note that the trial court certainly did not err in granting a directed verdict on the issue of deputy against negligence. He admittedly made a U-turn without looking to see if there was oncoming traffic, said he didn't see the bus, said if another motorist did what he did and he witnessed it, he would have ticketed him for failing to yield, said he, quote, absolutely made a mistake and is responsible for the accident. He was found internally by the sheriff's department to be at fault for the accident. And the video confirms that he simply did a U-turn, drove in front of the bus as it was proceeding towards him at 35 miles an hour. I don't think a jury could reasonably find that that was anything other than both common law negligence and negligence under the vehicle and traffic. So,
Mr. Collins, be mindful of your time.
yes, Your Honor. Just to wrap up, I submit that the trial court certainly did not abuse its discretion in precluding evidence or mention of plaintiff's criminal history, which, although not referenced during the course of argument here, was a major point in defendant's brief. The court concluded it would be more prejudicial than probative because defendants made it clear that they intended to paint plaintiff as a, quote, career criminal. And I think the court realized that was going to be the constant drumbeat underlying this whole defense of this case, given that the deputy was clearly negligent. They were simply going to attack the plaintiff, and the court said that's more prejudicial than probative.
I think we have your argument, counsel.
Thank you.
Thank you. Case 392, Viola versus SUNY Upstate University Hospital.
Good morning, Your Honors.
Counsel Robinson, I think we have your opponent appearing by video, so let's take one moment here.
Okay.
Counsel Mix, can you hear us?
Yes, I can hear you.
And we can hear you also. Please proceed, counsel. Thank you.
Good morning, Your Honors. It's Attorney Lisa Robinson on behalf of the claimant appellant Lori Viola in this case. We have filed this appeal from a court of claims decision that denied the motion to file a late notice of claim by Judge Rivera. We submit the decision should be reversed. The court of claims did find in our favor on 3 of the factors under the Court of Claims Act, Section 10, that there was notice to SUNY Upstate Medical University Hospital, that they did have an opportunity to investigate the claim and there was no prejudice. As set forth in our papers, we believe that the majority of the other factors also weigh in claimant's favor. So the decision should be reversed. In respondent's brief, they raised some of the issues regarding the merit of the claim. And as you know, the facts of the case involved Lori Viola, who was a psych ward patient who was alleging there was excessive force in the security guards and nurses who pinned her down when she refused medication. She had her arm pinned behind her back. The respondents are arguing she somehow injured her own arm by pinning it behind her back, but I respectfully submit that it wasn't the putting her arm behind her back that caused the injury. It was 6 people jumping on top of her with her arm behind her back that was improper to cause the injury.
There were 4 security officers and 2 nurses, and the nurses basically said, get off them,
After she started screaming, yes, Your Honor, yes. So
the medical records support that that there was those officers and nurses present.
Right, right. And, that also goes to the factor about if there's an alternative remedy, because I don't know the identity of the nurses and I don't know the identity of the security officers.
This
without-
wasn't a medical malpractice claim or anything to do with that. No.
Correct, Your Honor. I believe it's more of a negligence
It wasn't,
claim.
improper treatment that the officers utilized in pinning her down at all, right?
Absolutely right, Your Honor. I believe it was an improper restraint. And, I cited in my papers some of the statutes that were applicable and how they're supposed to safely restrain patients, residents. And I submit that, just based on the facts and what was in the medical records I did obtain, there is an appearance of merit. I only have to prove that there was an appearance of merit, and the judge
I
below.
think that's a Mattinson case.
I believe so, yeah.
Recently from this court, which indicates as long as it's not, groundless, patently frivolous or legally defective,
Correct.
it gives some notice. And I think the only factor which the Court of Claims indicated weighed in favor of the state was the reasonable excuse for delay.
Right.
It was a 3-month delay, correct?
It was a minimum delay.
That was more attributed to the ability to get the medical records, right?
Correct, Your Honor. In hindsight, now if I have a potential plaintiff or claimant in a psych ward, I'm going to submit a notice of claim even before I get the records. But because she was in the psychiatric ward, I did want to verify that the claim had merit before I filed a notice of claim. I believe that's a reasonable excuse. The judge disagreed, but I believe that all of the remaining factors weigh in our favor, and so the decision should be reversed.
Thank you, counsel.
Thank you.
Counsel, proceed.
Thank you, Your Honor. Sean Mix on behalf of SUNY Upstate in the state of New York. I'd like to start with the appearance of merit here. It was claimant bore the burden of establishing the appearance of a meritorious claim. And
You got to speak up a little bit, counsel. I'm not hearing you great.
Oh, I apologize. Is this better? Can you hear me now?
That's better. Yes, thank you.
Thank you, Your Honor. Here, a claimant simply failed to meet her burden of establishing the appearance of a meritorious claim, and that she failed to identify how or why the restraint used here was unreasonable. The medical records submitted with her motion show that at the time of the incident, claimant was suffering from active psychosis, suicidal ideation, and that she had an extensive history of self-harming behavior, which resulted in serious injuries to her person, including burning large swaths of her body, extensive head banging, and that at the time of the restraint, not only was she refusing medication to treat her mental illness, but she was also actively engaged in self-harming behavior, which warrants the need for a restraint. Moreover, claimant does not dispute that she was the one who placed her arm behind her during the restraint. She does not allege that the restraint was unwarranted. Generally, she does not dispute that she was refusing medication or that she was actively engaged in self-harming behavior at the time. She does not dispute that she was the one who placed her arm behind her during the restraint, which resulted in the pain to her elbow. And she doesn't identify how that restraint was improper or unreasonable under the circumstances, given the extensive history of serious self-harming behavior, her mental condition at the time, the conclusory assertion that simply because multiple officers were forced to pin her down, that was negligent without more just simply is insufficient to establish the appearance of merit.
It sounds like, Counselor, it sounds like you're arguing that it's inevitable that they're going to dislocate her elbow. That there's no way to restrain this person without dislocating her elbow. Is that the argument?
That's not the argument, Your Honor. The argument is that one, she placed her arm behind her back during the restraint. And during a restraint with an individual who is resisting medication, who is engaged in active self-harm, it's reasonable that might be flailing around during the restraint, that may place her arm. And given the number of staff involved to restrain her, that the elbow could become dislocated. There's no allegations that suggest that the restraint technique was inappropriate here.
Well, isn't a lot of your argument, it is something that would be more available or more relevant towards a trial rather than the notice of claim itself? Because at this stage of the proceedings, it appears as though the claimant has made sufficient allegations for a prima facie case.
Well, certainly there's case law suggesting that conclusory allegations of negligence alone are insufficient. And here, if you look at the motion papers, she doesn't provide any details, any evidence in the form. She could have put in an affidavit disputing some of this, that it wasn't because she placed her arm behind her during the resistance, that she didn't need to be restrained at the time. She could have disputed that and shown how the restraining technique was inappropriate. She didn't provide any of that. And so the absence of any evidence that this was an unreasonable technique under the circumstances, again, given her mental state at the time and her extensive history of self-harm, it's just a conclusory assertion that because she was injured, this was negligence, and that's insufficient to establish the appearance of merit. I'd like to move on to the other factors. Claimant has another available remedy here. She could bring a medical malpractice claim or an ordinary negligence claim against the individuals involved in the incident. It's unclear why this is insufficient, even if some of the identities of the officers aren't immediately apparent. CPLR 1024 permits her to bring suit against unnamed individuals. She also.
What if one of the doctors says, well, gee, I ordered them to restrain her, but I didn't order them to dislocate her elbow. What if the doctor says that? Wouldn't that provide a defense to the doctor?
If the doctor says, I ordered them to restrain her, but not to.
But not like that. Not where you restrain her to the point where her elbow's dislocated. Now you grab her that hard, you went too hard. What if the doctor was to just say that? Wouldn't the claimant be out of luck then? Because she just relied on her medical malpractice claim, not the negligence claim of the security officers.
Well, she could also bring a negligence claim against the security officers, which could then establish that if it's just for the claimed excessive force, then she has that remedy available. That's still within the limitations period. So she's not foreclosed from an alternate remedy here. And then finally, with respect to a reasonable excuse for the delay, all that was required to preserve her claim was to file a notice of intention stating the time, place, and nature of the facts giving rise to the incident. And all of that was within the knowledge of the claimant herself. She could have then taken the time counsel could have taken the time to review the medical records if she wanted and bring the claim within the limitations period. There's no reason why that information wasn't available within the time frame. So she failed to show a reasonable excuse for the delay here.
But counsel, it was a short delay and the witnesses are still available, correct?
Correct, Your Honor.
Anything further, counsel?
No, Your Honor.
Thank you. Case 393 is fully submitted. Case 394, Bianco versus Johnson. Proceed, counsel.
Please, this court, Melanie Wolf will be at the appellate. No, it's been a long morning already. I'm going to be brief, and I am also going to start where I think it makes sense, which is not necessarily in the order of the briefs that were submitted. I think the thing that makes the most sense to start with is the mootness argument, because if you don't get past mootness, we don't have a conversation about anything else.
Proceed.
As the respondent has raised that there's a mootness argument now because there has been a second amended complaint filed. In that second amended complaint, you will see that no allegations against the respondent have changed. And as everybody quotes, if there is still a controversy in effect here, and it affects the rights of these parties, there isn't a mootness issue. If this court decides summary judgment should have been granted, then that second amended complaint goes away and everything else goes forward. That's very easy. If you decide it doesn't, and you don't want to grant the summary judgment and you agree with the respondent, you still have that issue going forward in the underlying case. As you will see, it's kind of like the alternative pleading where, here's our real pleading, and if you don't buy that, here's the second pleading. That's what we had to do in the underlying case when we had to bring in the New York State electric and gas. So I think once we get past the moot argument, I want to move on to where we really stand here. I know you've reviewed the facts. This is a landlocked piece of property that does not have access to any electricity.
Well, those are two different things, arguably, right? It's landlocked. It doesn't have access to landlines coming across without the permission of your opponent. There is generator options available, right?
There is, and there is a generator, and there was an affidavit put in the summary judgment that the generator cannot keep the capacity of the house.
The current generator.
The current generator, and nor is there a generator that they between, and as we know.
There's no generator that's made today that could operate the requirements of that home.
That is how the appellate put the affidavit in. Yes, that is what they say. Now, if you look in this appellate argument, there's an argument made about experts in that. That wasn't made in the underlying case. There was no argument that you need a different generator or a bigger generator. That wasn't set. That's new. And there have been a few things, and I don't really mind the mootness argument. That was obviously allowed, but there's some new arguments that have been put forward by the respondent here that were not put forward in the underlying case. That goes with the.
So they're not appropriately before us.
They're not, as well as an expert in regards to the title search or the surveyor. So those are the two things that really stick out to me when I read these briefs that weren't there before and aren't before this court. So you have a person who bought property, and clearly the neighbors aren't going to get along. And
Is there a question of fact on whether or not it's absolutely necessary to go and utilize the pole on the defendant's property? It doesn't appear as though there was any alternative other means. I mean, the generator was discussed, but there wasn't appear that there is another pole that can be used. Maybe it's a little further away, maybe it's a little more expensive. This one's just more convenient. We like this one better. So it's an easement of necessity and
as this is set up, so you'll understand that you've got a highway that runs, you've got this farm, the respondent's farm, and then you have this giant wind farm. And they don't have electricity on that wind farm because they're operated by wind. So this isn't just the easiest way. It really, quite frankly, is the only way. If you were to try to do it some other way, I can't even fathom how how New York State Electric would get it from there across and over a wind farm or over the highway. It's just, this is the way to do it. And it's not that far. You know, it's for lack of simplicity. You know, if this was someone arguing over a fence, if it was in the right place or not, you know, it's just something that this court says, you know, look, if you own land, you have the right to have some electricity, especially if you can't generate it any other way, which is what was shown in the underlying summary judgment.
So let me ask a question and just clarify the record for me. New York State Electric and Gas does have an easement over the respondent's property, correct?
That is our position, yes.
Yeah, and they've been asked to exercise their easement, but their position is, and understandably, hands off until you get a court order that tells us we can utilize that easement.
Absolutely. And well,
because the easement is probably for the benefit of the respondent's property, not for the benefit of your client's property.
That is
fair?
Initially, yes.
Yeah.
Yes, because that easement came in from a third property back in the 40s to allow the respondent's property to have electricity. We're literally sitting in the same position that they sat in the 40s. We're asking for that electricity to come on over. It's pretty simple. While there's been some discussion as a tribal issue of fact has been raised over that correspondence with New York State's electricity, it doesn't say anything. It's kind of like me going to my neighbor and saying, I think your fence is in the wrong spot. It doesn't have any clout. Doesn't mean anything. And quite frankly, if I was in their spot and we've got two neighbors arguing, I don't know if I would do anything either without a court order or someone telling me you have an implied easement here to put it over there and do it.
So are you saying that this incident, your motion was not premature? There was no need to examine or depose any other witnesses or other discovery?
No, Your Honor. So at this point, there's no complaints. There's outstanding discovery in the appellate respondents. So they got everything. Their big star, big, you know, hey, this is our winner, is that correspondence with the New York State facility utilities. And that just says, we recognize there's an easement, but we're not going to do anything until you have something else. That's what it says. It doesn't say we don't recognize the express easement. It doesn't say we don't recognize that there's potentially an implied easement there. And even if it did, It's somebody at a public utility company, not a court, and definitely not a summary decision.
So did your client start construction on their house before they realized they didn't have access to electricity? Or just presumed, hey, there's a pole over there, we're gonna connect to that one over there because that's nice and close to us and we're good for that.
I can't tell you what was in my client's mind, but I can tell you what I think.
That's probably what happened, right?
Well, yeah, and I think the average person thinks, and it may have been advised, that you have a landlocked piece of property, there's an easement showing up on all the surveys and in the title deed searches, you're going to be able to get electricity. We'll just take it from the next property that has it. I mean, who today doesn't have it? Unless you're going off grid. I won't be doing that anytime soon. Who today doesn't have electricity? We live in a world where everything functions off of it. And, you know, I understand, and I will end very quickly, because I think we all understand how neighbors don't get along and how there may be some bad blood between these two parties. But to have that be what stops someone from being able to have the quiet enjoyment of their home with electricity seems just a little out of where these courts are going today.
Thank you, counsel.
Thank you.
May it please the court, Erin Elmouzi for respondent Jacqueline Johnson. I am also not going to take too much of your time. I'm not going to rehash all of the arguments that are in our papers. Our position is, in fact, this is a case where the court is spoiled for choice in the reasons that it can either dismiss this appeal or affirm the trial court's order below. Initially, we do contend that this appeal is moot. Counsel is not correct that if this court should decide that summary judgment should have been granted on the prior complaint, the second amended complaint goes away. That's not how it works under the law. When appellant decided to amend her complaint and name NYSEG as a party, under the CPLR, the respondent as well as NYSEG had the ability to respond to the second amended complaint. The prior complaint became inoperative as a matter of law. The parties are also permitted to chart a different course on the second amended pleading, and they have done so. NYSEG and respondent both have currently motions to dismiss the second amended complaint that are pending before the trial court. So it's not accurate.
Still with Judge Cook?
It is before Judge Cook, who was not the justice that heard the summary judgment argument, but was the one that entered the order because the prior judge retired.
Is there some dispute, but that this easement exists in favor of NYSEG?
It is not a dispute that the easement exists or that it's in favor of NYSEG. The questions of fact that would have prevented summary judgment have to do with whether or not the appellant can enforce NYSEG's easement. Because the appellant is a stranger to this instrument. There was no discovery about whether or not there was some sort of assignment or under what basis they are claiming the right to enforce NYSEG's easement. The language of the easement also states that it terminates at respondent's home. There's nothing in the language of the easement that indicates it was intended to cover the entirety of the combined parcel, and NYSEG, in the discovery that we were seeking at the time appellant moved for summary judgment, NYSEG had communicated this to appellant, and I will say that because the court asked about it, the communications that have since been produced have established that appellant was informed by NYSEG prior to constructing the residence that an easement was required for electricity.
Counsel, can I ask a question? What's the practical impact on your client should it be found that this easement allows for this electricity to cross over their property? In terms of what difficulties cause your client, both in terms of time, inconvenience? What is it that's causing the problem here?
Sure, it would depend on what the finding is, because the way that the appellant is interpreting this easement is that they could, because it was intended in their mind to cover the entire parcel, they could run electricity anywhere they wanted across my client's property in order to get to their property. They have identified a specific route, and their client has made the statement that NYSEG tells them this is the only feasible route. We don't have any of this.
Clients actually looking for some type of ruling that limits the extent of the easement that crosses their property, so that there's some control over where that electricity runs. Is that what That's where the problem lies?
No, our position is that the NYSEG was granted to the easement was granted to NYSEG and it only ran to my respondent's home, to our respondent's home. And that there is no easement that runs to appellant's property, which at the time of subdivision and for decades thereafter was vacant land. It was farmland.
So there was a subdivision. In a sense, that's two pieces of property we're talking about here.
They were previously combined parcel, and at
Right,
the
but-
time of subdivision, there was no need for
But
electricity.
the one parcel has been subdivided.
It has, yes.
All right. Those houses don't have electricity either?
So there were no houses, that's the thing. There was one house on the previously combined parcel. That is the house that my client lives in.
Right.
And-
Then that was that's the one that apparently gets the easement, but apparently that there was a unity of and a subsequent separation of the one parcel into more than one, into many, not more than two also, right?
Correct. We do not dispute that there was unity of title. We do not dispute that there was a subdivision. The problem is in order to
So how
create
these
an
other-
implied easement.
How these other, properties in the subdivision getting electricity?
If I am correctly reading appellant's papers, there were additional easements granted to NYSEG for other properties that have homes on them. When appellant's property was subdivided, it was vacant land. It was farmland. No easement was granted. And appellant was informed of this before constructing a home on the property. That
So
it
when the
needs to be
subdivision was
required.
created, this parcel was not included in that basic subdivision.
It was subdivided as vacant land. So there was no prior use for electricity to be run to that property. There was also no necessity for electricity to be run to that property because it was vacant land at the time. And these were the issues that, had discovery been permitted to proceed, we would have explored through depositions of appellant to understand the intent of the parties when the easement was granted, to also understand whether or not there are alternate routes that electricity could be routed to this property, whether the other sources, including wind, solar, propane, the generator that the court mentioned, are feasible options, because in order to get an easement by necessity, it has to be absolutely necessary. Not electricity has to be absolutely necessary. Running utility lines in this route across my client's property has to be absolutely necessary. We weren't able to ask those questions. It's my understanding that the wind farm that is referred to is owned by affiliates of the appellant. And it may be that running utility lines across that wind farm would be extraordinarily expensive. That doesn't make it an absolute necessity under the law, and we just didn't have the opportunity to explore that.
So it's in your argument, it's premature.
We think we have several arguments, but yes, we believe it was premature. We believe the prima facie burden was not met and didn't shift to our client. There's several issues of fact that preclude summary judgment.
Very good. Anything else, counsel?
No, unless the court has questions, I'll rest on my papers.
No questions. Thank you, counsel.
Thank you.
Case 397, O'Grady versus Auburn Enlarged City School District et al.
Good morning. My understanding is we're waiting for a video participant. There he is. Okay, good morning, council. We can't hear you. We can't hear you, sir.
Is that better?
That's a lot better, but if you could make it a little louder, that would even be more better.
I honestly don't know, but I will speak up.
Okay, that sounds better already, sir. Why don't you proceed?
Yes, may it please the court. My name is Michael Dowd, and I represent the plaintiff appellant in this case. Her name is Pamela O'Grady. This is a Child Victim Act case in which the school district, which was a defendant, was advised by parents that a member of the faculty and a band leader, Thomas Camp, was engaged in an illicit relationship with the student, Pamela O'Grady, who was a minor at the time. On 3 separate occasions, the district found or representatives in the district found Ms. O'Grady and Mr. Camp, the band leader, behind locked doors. On one instant, a assistant principal, unlocked the door to the band room, and when opening it, saw the plaintiff getting up from Mr. Camp's lap.
So that we had a trial in this case, right, sir?
Yes, Your Honor.
Okay, and I think your appeal, it deals mainly with the findings of the jury.
Yes, Your Honor, it does.
Okay.
I'll
Well,
get.
why don't you go to that?
Yes, I will. The jury's verdict was tainted by several things. One, in the first instance, there was testimony produced by the defendant that through a deposition that
That was Herbert Dickinson, right? Dixon.
Herbert Dixon was the person that he through the deposition testified that he was at a meeting with the
Was that counsel, was that preserved below? I don't see in the record that was preserved at all.
Oh, yes, Your Honor. There were specific objections to that because the transcript of that deposition was presented to us, and we underlined those portions of the transcript which we objected to for one reason or another. And in this case, the one we're talking about, the part we're talking about on the grounds that it was hearsay. It was preserved, absolutely. At any rate, the Herbert Dixon testified that he was in his deposition, that he was at a meeting where the principal and he were present with the the plaintiff's mother. Now, the plaintiff's mother testified and completely denies that she was ever at a meeting with Dixon and the principal at any time. The Dixon testified that at the meeting, the principal advised Mrs. Deacon, who was that was the plaintiff's maiden name, the mother, that of the suspicions that Mr. Camp was sexually abusing or involved in an illicit relationship with her daughter. And then went on to testify about the responses of Mrs. Deacon to that being advised by the principal. We objected to that as hearsay. And the point is that, the defense argued that these statements were being offered not for the truth of the matter, but just that the statements were made. Well, if that was the case, and the point was to just establish there was a meeting between the three people, Dixon could have testified, I was at a meeting with a principal and Mrs. Deacon, period, end of quotation, as far as that didn't concern hearsay. How that affected and infected the jury verdict is that subsequently there was at best a condition at which the judge during the charging conference, which was unfortunately we were engaging in because the judge was driving from Rochester to the courthouse in Auburn. So it didn't get recorded, but when it gets picked up, the plaintiff's counsel at the time said, Judge, you've satisfied us that the jury instruction 2:262 is satisfied by the judge's prohibiting the defendant from making any kind of a allusion in his summation that there was any negligence on the part of the mother. Now, during that summation, the defense lawyer actually said that the meeting happened, that everything indicated that everything was fine between Mr. Camp and the plaintiff's mother. It was only after the meeting at which she was alleged to have participated that she changed her opinion of Mr. Camp. And in fact, in his summation, defense counsel argued that that is proof positive that what Mr. Dixon said in his deposition was true, when it had previously only been and ever offered not for the truth of it, but that it was said. The difficulty with that is when you got to the instruction, when you got in the point of the summation, before the jury instruction, the difficulty is that the judge promised or ordered the defense not to comment on or any negligence of the mother bearing on the case. And obviously, which we submit is really black letter law in New York under the general obligations law, that you cannot impute negligence from a parent to a child plaintiff in a case. So that by the defense has argued that the counsel for the plaintiff waived the objection to not charging 2:262. But if you read the transcript, it is plaintiff's counsel saying, Judge, after the judge says he's going to prohibit the defense from arguing in the summation negligence on the part of the mother affecting the case. And then during the summation, plaintiff's counsel objected to essentially the defense counsel violating the direction and order of the judge prior to the beginning of his summation. The judge gave, at that time, certainly was obligated to give a curative instruction that embodied the notion that a jury could not consider or hold the negligence of a parent against a plaintiff, a minor plaintiff in a case like this. As they say, it's Hornbook law. And, they argue waiver, but we argue it was not. But at any rate, here's where another part of the problem happened.
Well, aren't you arguing in this instance concerning the waiver? I mean, the judge asked if you were satisfied with the charge, and there was no objection to the charge being made. But again, you're contending that there was a improper reference to the mother made by defense, but the court gave a curative instruction.
They did not give a curative instruction. They did not. The judge, counsel for the plaintiff, was asked essentially just before, did the judge's order to directing the defense not to bring up the matter of negligence on the part of the mother as affecting the plaintiff's case, and the plaintiff's counsel said, in that case, Judge, I think the matter is taken care of. But the point is that during the summation, the defense counsel did not comply with the order of the judge and was.
And remind me, counsel, remind me in the record, when counsel violated the court's instruction to not bring up the mother's negligence, when that occurred, was there a timely objection?
Yes, Your Honor. You can look at page. There was a timely objection made at the time.
And what was the court's ruling at that point on the timely objection?
That it was overruled and the jury was instructed that this is summation and not evidence. And there was no curative instruction of any kind. It's certain what the plaintiff is arguing, at a minimum, at that point, the judge should have imparted to the jury the content, substance of the PJI 2:262.
Well, what did the remind me, counsel? What did the judge do then with the charge relative to that section? Did the judge address it during the charge?
What he did was, and I think this is another part of the case, which is a little complicated. The judge, seemingly charged the jury, never charged the jury about considering the mother's testimony in any regard. They were left free to roam, if you will, with that. When he charged the jury found that the school district was negligent.
Whoa. Hold on a second. My question is very simple. Did the charge include reference to the mother's negligence not being considered? Was that language? So there's no charge to the jury that would.
Nothing.
Let me finish. There's no charge to the jury at all that would have cured the problem that was raised in summation. That's your recollection of the argument or the record.
I can read it to you. I have it.
No, you don't have to do that. You don't have to do that. All right. So your argument is something had to be done. There was a timely objection. There had been a previous ruling. The court's only curative instruction was that this is argument by counsel. It's not evidence, essentially. That wasn't enough. And there was nothing done in the charge to correct that so that it could leave the jury with the ability to decide whether the mother's negligence was or was not some contribution to this problem, right? Is that
exactly? But it complicated what the jury was asked to find. The jury did find that the district was negligent in its supervision of the plaintiff. In other words, the district had an obligation, as a reasonably prudent parent would have, to protect a student in its care from just the kind of thing that happened in this case. And by not doing anything to inhibit the free access of the predator to the plaintiff, it's inescapable that there was a second question asked: was the negligence of the school district an important factor in the case? The problem is that—
Hey, counsel, I'm going to interrupt you just for a second and let you know that your time is up, so you need to be wrapping up now.
I will wrap up. The point is that the way it was left, when the second question got asked, was the district's action or negligence a contributing factor? The jury was absolutely free to consider the alleged negligence implied in the content of the case without limit of any kind.
Very good. Thank you, counsel.
May it please the court, Charles Spagnoli of Ferrara Fiorenza, representing the Auburn Enlarged City School District and its Board of Education. Plaintiff in this case was afforded a full trial before a jury at which she was ably represented by Mr. Dowd and by Miss Georgia Kosmakos. During the trial, evidence was elicited that plaintiff and defendant Thomas Camp engaged in sexual contact numerous times off school grounds prior to his resignation. And then following his resignation, they continued to engage in sexual contact on a daily basis without detection. In fact, plaintiff testified that by her estimation, between the time of his resignation and her graduation from high school a year later, they had sexual contact without being detected 350 times. The jury found that...
Counsel, just so I understand what you're saying, did I hear you just say that before his resignation, the only sexual contact was off school grounds?
No, Your Honor.
Okay.
Significant sexual contact took place off school grounds. She testified that some took place on school grounds as well prior to his resignation.
Mm-hmm.
But the point that I'm making is that even after he resigned and had no contact with her on school grounds, they still managed to engage in sexual contact, according to her testimony, on a daily basis. The jury found that the school district...
What does that... You're making that point. What does that point... What's the point you're driving home with that? What are we supposed to take from that point?
The jury verdict found that the school district was negligent in its supervision, but that such negligence was not a substantial factor in causing the occurrence of the sexual abuse.
How does the point that you're making that there was a continuation of the relationship after he resigned? Draw the line between those 2 points for me.
The jury logically could conclude that even if the school district had ramped up its supervisory efforts to a point that the jury found acceptable, these two still would have simply shifted their...
Had the school district done what it was supposed to do in terms of protecting the child and the relationship was never started, might it be that when he resigned, it never would have continued?
There was no evidence adduced at trial that the school district's negligent supervision was the cause of the start of the
relationship. Let me restate that. If in fact the relationship never happened before he resigned, no relationship, is there any evidence that the relationship would have begun afterwards? In other words, is there no connection between what was happening on the school grounds before he resigned to a continuation with this young, impressionable woman? You're saying that that continuation would have happened even if she wasn't impacted by this relationship?
Your Honor, our argument and what the jury apparently found was that regardless of what the school district did to try to supervise these people within reasonable bounds, they would have engaged in this conduct anyway.
But his conduct, I understand your point, in the separation between the school district and what information they had, what they didn't have. I understand that. But Mr. Camp's conduct that took place before his resignation certainly had an impact, and that conduct happens on school grounds. That conduct certainly had an impact on what happened after he resigned. You would agree with that, right?
I would agree that there is a continuing course of conduct between plaintiff and Mr. Camp, but based on the facts...
So when you make the argument that because this relationship continued after he resigned, it's some indication that no matter what the school did, that it would have just happened anyway. You understand my frustration or trouble, I should say, with that argument. If Camp is the one that begins this grooming and this conduct that he admitted to, if he does that on school grounds as a school teacher, then and that continues, we can't. I mean, this is no indication that this child is consenting to this relationship afterwards.
Absolutely,
and it would have happened anyway.
Absolutely agree. There's no issue of consent here, and she was not legally capable of consent. But these facts were before the jury, and the jury found there was no causation. And there has been no error shown, no improper evidence before the jury that affected that determination.
Address your opponent's argument with respect to referencing the mother. You'd agree with his statement of the law that a parent cannot be responsible, cannot be, the negligence of a parent doesn't come into play in this litigation, right?
Yes, Your Honor. And plaintiff's counsel referenced a point in my closing argument where I referenced the fact that the school district had learned Miss Deacon, the mother, had given permission for the child to be driven from school by Mr. Camp and had given permission for him to invite the child to the school on weekends, supposedly to assist him in working. Those statements were made right in the body of a section of my argument where I was expressly trying to establish that the meeting that Mr. Dixon described in his testimony had occurred. And the reason that was significant was in their summary judgment motion papers and in his opening statement, plaintiff's counsel had argued the school district did not adequately investigate, which should have involved interviews with the parents. So we were showing that there had been an interview with parents, particularly the mother.
Remind me, in your summation, did you specifically make reference to the mother's negligence?
I made no argument whatsoever that the mother was negligent or that the mother shared any culpability. I had been citing the factors that showed the meeting Mr. Dixon described actually occurred. I had already dealt with one point. I turned to the fact that the mother had been fine with him giving rides to her daughter. But then after that meeting, at some point, she challenged her daughter as to whether she was out with Mr. Camp. And when and this is at, I believe, pages R918 to 919 of the record. It's pages 911 to 912 of the original transcript of the trial. When Mr. O'Dowd objected to that, the court instructed the jury that my comments were not evidence. Following that, I expressly disavowed any attempt to suggest negligence on the part of the mother and explained to the jury that I was bringing these things up solely to show that that meeting between Mr. Dixon, Mr. Orofino, and the mother had occurred, which was relevant. Plaintiff has argued that the jury's findings, negligent supervision, but not a substantial factor, not causation, are inconsistent, and that those should not have been allowed as separate interrogatories.
Would a reasonable parent acted differently in the event that behind closed doors in the band area was Mr. Camp, and when the door was open, it was revealed that the plaintiff here was sitting on his lap?
The jury found that apparently found that a reasonable parent would have done differently because they ruled in favor of the plaintiff.
Investigated a little bit more as far as that's concerned. I mean, it just seemed to go on for quite some period of time.
It did, but the jury's finding based on the facts before it was that even if the school district had supervised
all those actions were in itself, they were negligent. They were found to be negligent in that regard by not investigating further or doing other actions to prohibit this from happening.
Of course, we only have the jury's ultimate finding that the school district was negligent in its supervision. We can speculate that that was part of the basis for that finding, but that finding by the jury dooms plaintiff's arguments because almost all of plaintiff's arguments regarding error go to whether the school district was negligent in supervising the plaintiff and not to the question of whether that negligence was a substantial factor in the occurrence of the abuse or whether the abuse would have occurred regardless of what level of supervision the school district employed. This court, less than a year ago, issued its decision in Held versus Cheektowaga Sloan Union Free School District, reported at 240 AD 3rd, 1369. That was a Child Victims Act case in which a student claimed that she had been subjected to sexual abuse by a teacher. This court held that the jury's finding that the school district was at fault, but that its fault was not a proximate cause of the injuries in a Child Victims Act case was not inconsistent and not impermissible. This court held that those two findings are inconsistent and the subject of reversal only where the issues are so inextricably interwoven, quote, as to make it logically impossible to find negligence without also finding proximate cause. The court further stated, under the facts of this case, it was logically possible for the jury to find negligence without also finding proximate cause. The jury could have concluded that the district's negligence was not a substantial factor in bringing about plaintiff's injuries and that the teacher was the sole proximate cause of those injuries. Where a verdict can be reconciled with a reasonable view of the evidence, the successful party is entitled to the presumption that the jury adopted that view. That's at page 137.
Yeah, and that's a fair statement of the law. And your argument is that even though those are very fact-specific rulings, right? It depends upon what's before the jury at that time and whether or not a jury could reach that conclusion, find negligence, not find proximate cause. You're saying that that case held it in that case, yes, that's a fair finding. Could have happened.
Absolutely.
And you're saying this case resembles that. In other words, it's the same thing. The jury could find negligence here and still not get to proximate cause.
I'd say that the evidence in this case was stronger on that point because there was such a welter of evidence that these two individuals were engaging in substantial sexual contact outside the school district, even after he resigned and had no contact with her through the school district. The other errors that plaintiff has raised, again, we've argued in our briefs, were not errors. Some were not preserved and some were expressly waived. The testimony by Mr. Dixon was that statements were made, and the fact that those statements were made had significance, so that's not hearsay. They did waive their request for a 262 PJI instruction at page 891 of the record. And the fact, again, that there was a negligence finding dooms most of their arguments. The court, I should note, was careful to instruct the jury on the issue of substantial factor or causation, and expressly told the jury that there can be more than one party whose acts are a substantial factor in bringing about an occurrence. And the fact that a party's participation in that may be low does not necessarily mean that it's not a substantial factor. So when the jury was looking at that issue, they would not have been looking at what was the negligence of the mother, even if there were facts that came out in the trial that might have suggested that. Certainly not argument by us. What they would have been looking at solely is the alleged negligence of the school district and what role it played in the occurrence of the abuse. Now, Mr. Dowd can claim to his dying breath that we argued before the jury that the mother was negligent and that this produced the sexual abuse. The transcript is before the court. That argument was never presented by us to the jury. The judge ruled that we could not make an analogous argument. We stayed completely away from that. To the extent that facts were adduced in evidence that a jury might have, without prompting by us, leaped off of to suggest that the mother was negligent, that's not an error, and there's no indication that that's what occurred.
Counsel, your time's coming to an end.
Thank you, Your Honor. I believe I've covered all the points. Again, the jury actually found negligence in this case, which paradoxically dooms plaintiff's chances on this appeal. Thank you.
Counsel, thank you. Case 398 and 399, Carrier Corporation versus Allstate Insurance Company. Counsel, proceed.
Riley Mendoza on behalf of Appellate Fireman's Fund Insurance Company. There are 3 issues we have on appeal. We have trigger and then 2 discrete coverage issues. I'm going to cover trigger first. The second 2 issues are based largely on the policy language, so I'm not planning to spend a lot of time on them given our limited time and the complexity here. So on trigger, you have to prove bodily injury during the policy period. This court repeatedly, including during the last appeal on this case, and then more recently in the Meisner case in 2024, has held that the correct trigger here is injury in fact, and that is when the injury or the disease begins. This court directed Supreme Court on the last appeal that Supreme Court needed to determine injury in fact after exposure as an issue of fact, not as an issue in law.
Why is it inappropriate for the court to not rely on a carrier's expert in terms of how the asbestos enters your lungs, et cetera, and what takes place microscopically?
After the trial. So he can, of course, listen to the different experts and decide who has the better testimony. But his ultimate ruling that trigger came at occupational exposure was not in that expert's testimony. That it was directly contradicted by the expert's testimony. To get there, he basically had to accept Dr. Gabrielson, which was the plaintiff's expert, his testimony that the molecular and cellular changes that happen to all of us all the time, they're happening to you right now. When you inhale particles, including asbestos particles, things happen in your body. He had to use that testimony and call that injury. But that is directly contradicted by lots of Gabrielson's other testimony, which is that it takes years of exposure for there to be an onset of disease. That people who are just exposed to the ambient air, like all of us, there's no prevalence of asbestos diseases. That even people who are occupationally exposed, Gabrielson testified, most of those people do not get an asbestos-related disease. So while yes, he can weigh the testimony, the ultimate conclusion here on the medical evidence was not supported by that testimony, and frankly, glossed over that and found a ruling that was essentially another ruling as a matter of law that it's an exposure trigger.
And you're saying that once exposed, the expert testimony would be once it's exposed to the asbestos, and the asbestos is in the body and embedded. That's not enough. There has to be some manifestation of some of the disease for that to become actionable.
No, we're not saying it has to be manifestation. And just on your premise, inhalation does not necessarily mean that the asbestos fibers are embedded in your body. The testimony of all the expert was that 98% of the fibers that come into your body, even on people who later are diagnosed, are worked out by the body's defenses, leave the system, they're not embedded. So and we're not saying manifestation, we're saying onset of disease, which is what Rapid American said has to be the trigger. It's onset of disease. So if you look at the Keesby decision.
So is the implementation, is the embedding of the asbestos in the body, I'm trying to simplify this for my understanding. So once the asbestos is embedded in the body, you're saying a lot of times it isn't embedded. It flows out and the body has miraculously a protection mechanism and it's not a problem. But you would agree then that once it's embedded, that is when the disease is manifest.
No, I wouldn't agree with that.
That's where I want you to talk to me about.
Okay, sure.
So it's not enough that it's embedded. So let's get off the idea that the body discharges some of this and it may not have been embedded. I want to know if it's not when it's embedded, when is it? What has to happen? What's the trigger then for this to become?
So there are a certain amount of asbestos fibers that all of our lungs have and can handle. It's when your systems are overwhelmed and the disease process starts. And our expert provided some timing of that. If you looked at the Keesby decision, they also provide some framework on how frankly, we don't have to prove that here. They have the burden of proof that it was during two policy periods in the late 70s for people who are being diagnosed recently. I mean, these are for settlements that were in 2014 and 2020. So to be clear on what they need to prove here, 2014 to 2020, people were paid for asbestos diseases. They're asking us, they need to prove that the onset of those diseases, say someone who was diagnosed in 2015, that disease began in the late 70s. And the Keesby decision shows why that doesn't work under New York law. So in Keesby, they were basically trying to prove an exposure trigger in Keesby, a very similar thing. The court said, that doesn't work. We can't accept exposure as a matter of law, and the science, and it went through some of the similar science that's before the court here. The science is that it takes a lot for the body to get overwhelmed. Thankfully, it takes many, many, many years. So they have not proved that it's at exposure, which was what they had to do in Keesby, because it was an operations policy, which required basically exposure trigger. And here, they are asking for an exposure trigger. Exposure on significant occupational exposure is where we are on the trigger here. But
you're saying the only argument for us is if it's not exposure trigger, that was where the problem lies. And actually identifying when it would be triggered isn't important for us to consider?
You don't have to decide exactly when exactly it was triggered here, because
But exposure triggered, it's not, your argument is it is not triggered when there's just exposure.
exactly. And I don't think the evidence supported that. So I think your ruling would just need to be that they have not proved that there is onset of disease at first occupational exposure. That's what
Understanding that that's the argument that you made. Do you have an answer to my question though? About what is the trigger? When does it trigger?
Sure.
That was the question.
Yeah, fair enough. So, so our experts put forth a pretty clear timeline. Mesothelioma, which is a very aggressive cancer caused by asbestos, our experts, and this was undisputed testimony at trial, said that the last mutation that starts that means you have cancer, it's no more than 2 to 5 years before diagnosis. So if someone was diagnosed in 2015, they did not have cancer earlier than 2010. For the other cancers that you can get from asbestos, like lung cancer, they put that timeline at 5 to 10 years. So someone who was diagnosed in 2015, they did not have cancer before 1995.
Doesn't diagnosis require somebody to go see a doctor and tell them about what they're experiencing, and then the doctor has an opportunity to do some tests and do a diagnosis? What if somebody delays going to the doctor, which there's a lot of people that should be going to the doctor and they don't go? How does diagnosis enter into when the actual the disease manifests?
Well, diagnosis could be you're about to die from mesothelioma. You know, it's a very fast growing cancer. It's usually you're diagnosed and you're unfortunately dead very soon after you notice it, when you start being unable to breathe. So, and again, well, I'm not saying that the trigger is diagnosis. I'm saying that by the time you're at the point where your body is reacting and a doctor could diagnose you, or you're feeling like you cannot breathe and are very impaired, you've only had this disease at most for mesothelioma for 5 years. And then for non-cancers, there's not that clear of a timeline, but all the medical testimony, and this has been true since Keesby, is that it takes years of exposure. It is not on first occupational exposure. The medical expert testimony is clear that to reach the burden where your body can't handle it, you know, and I think one analogy one of our experts used is the bathtub. You know, some's coming in, some's going out, and until you hit the point where your body just cannot handle the load that's coming in, that's when you get persistent fibrosis and you get scarring that the body can't recover from, and you're on the disease process. You have the onset of the disease. So that's the timing. Just because the time is going quickly, I'm going to move to, so first they have to, that's the first reason that this trigger decision should be reversed.
I know you want to move on, but with respect to this issue, just so the way that this should have played out, then plaintiff has a, let's say, 15-year exposure to asbestos from the plaintiff's products, because they worked on them all the time, and they show it, and then they at some point develop lung cancer, and so they bring the claim, and that's it. And all the plaintiff cares about is that they have an expert that can link the 15-year exposure using plaintiff's products to the ultimate lung cancer. At that point, though, the plaintiff has to think about, all right, during those 15 years, which policies did we have? When was it triggered during the 15 years? And so you're saying then the plaintiff then, if they want coverage for that, has to demonstrate within that 15-year period, all right, when did it happen? When did the disease occur? Because it's not when the diagnosis is lung cancer. You agree to that, but you're also claiming it's not first exposure either. And it would seem to me it's on a sort of a case-by-case basis, right?
Absolutely. I mean, so if an asbestos case goes to trial, you have to prove general and specific causation. That's what you have to do. And then if the defendant's wanting coverage, you know, if they pay out to the plaintiff, they want coverage. They need to establish which policy periods the bodily injury was in. They can't just pick any policy period from the beginning of time until present. That would destroy the whole bodily injury requirement.
It seemed that they would be starting with the policies from the date of first exposure. Part of that doesn't matter. And the date of diagnosis of lung cancer, because after that doesn't matter, right? So and probably actually they'd be limited to the whole exposure period. Even if there's a latency, that doesn't matter really either, right?
No, it would matter. I think you're right. You would look at that broad period And you'd have to decide, a jury or a judge would have to decide which policies they had proven there was more likely than not to have been bodily injury.
The plaintiffs claims that they've contacted all their carriers, including the excess carriers, and said, hey, come aboard here. We're going to give you notice. We've got these claims against us. We're trying to defend them. We're trying to analyze them. Come and see. Come and help us. Come and participate. And your client said, well, we don't really have to do that. It's still their burden. That's the argument I'm reading that you're making a reply.
Absolutely. We didn't even know what claims they were sending to us, because what they were doing was they were telling all the different insurers of all the different policy years, we haven't picked what policy year we're going to go for yet. Here's all these options. It could be you, it could be you, it could be you. And then they settle with a bunch of people, and then last man standing, it's you. And so that's what happens to us. And of course, before we know what claims are coming to us, we can't decide if there's bodily injury we can't make a coverage decision. How would we even participate? Why would we participate? We don't even know those claims are coming to us. That we're a small part of the big picture here. Unfortunately, we're the last people standing, but we on their big insurance program, we were not the major target until we were the major target. So just to get to the second point, because I do think it's really important that they have to do medical trigger, but then they have to prove all of these claimants had significant occupational exposure during our policy period, and they didn't do that. They had the date of first exposure, which is DOFI, and we had another trial. This appeals from 3 different trials. The last trial in 2025 was to determine, under the new trigger ruling, first significant occupational exposure, whether they could prove that the claimants actually had that. So they came up with a new definition of occupational exposure for that trial that they gave to their experts. Wasn't in the Supreme Court's ruling, but it was basically someone who was occupationally exposed or had a non-occupational exposure that was similar to the occupational exposure, or lived with someone who had an occupational exposure. It was like a very convoluted definition that basically was seeking to encompass every potential claimant of carrier. But the testimony from their allocation expert who made these determinations was that he included really weak exposures in the allocation. It's not significant exposure. In fact, in his expert report from 2017, where they first said they might come after Fireman's Fund, he said, I included very minimal, and this is at the record at 2583, I included very minimal exposures in my allocation to Fireman's Fund because, quote, even limited evidence of exposure to asbestos in carrier or Elliott product, such as evidence indicating that an underlying plaintiff was in a plant where a product was located, presents substantial litigation risk to carrier or Elliott. So they've already told us, we've included, if someone just happened to be in the same plant as a carrier air conditioner, they're counting that as a first exposure. And we know that's not significant. I mean, it's just 100% clear there's not significant exposures here, that it's any date of first exposure. So if you're going to really hold them to what the trigger they chose, or they had to choose, because that's what the experts all say, you need significant exposure. They all agree on that. Then you have to hold them in the second trial. Well, then where's the significant exposure for these claimants? And they do not have that. And they admit that, and they say, they basically admit that because it's all over the place. And they say, we don't need to do that because we settled and we made good faith settlements, and they were good settlements. And to be clear, we're not saying they were bad settlements. Of course they should settle a case if it's going to cost more to go to trial. You can't get out on motion for summary judgment, which is what really this happens. If there's any mention of carrier products, they say, we're not going to get out on summary judgment. We should settle it, avoid trial. Totally fine to do that. But they still need to prove bodily injury if they want 77 to 79 to pay for those claimants. And they just don't have that evidence. They didn't have like at a trial. A lot of these trials you'll see like an industrial hygienist, which will say, if you were this many feet from this product, this is how much asbestos you're bringing in, because otherwise you can never come up with these calculation of a substantial exposure. They didn't have that. They had their defense experts saying, we made good settlement decisions. And we do not question that. I think, they ran a great program. They were qualified people. They knew what they were doing. We have no qualms with that. But doesn't relieve you of your obligation if you're asking us for policies 40 years ago to pay millions of dollars. You still have to show us that there was an injury during our policy period.
we were to conclude that they're gonna need enormous cooperation from plaintiff and plaintiff's doctors, and plaintiff in the underlying litigation, the 9,000 claimants, they're gonna need a lot of cooperation from them. Your answer is, well, that's their problem.
They settle these cases. If they wanted to get that cooperation, they could have done that. They don't have the evidence. That evidence doesn't exist because these claimants were often settled on very weak evidence. And they admit that. They settle cases where there's weak evidence of exposure. So there's not, and it's not a huge amount of claims. It's like less than 1,000 claims. So they certainly could have, before they settle a case, say, we need this evidence from you. We need an affidavit that says that, there's ways you could do it if you're focused, if you've made your decision on what coverage you're seeking. I think that's part of the problem here is we did not get a definite claim, which is one of our issues, until December 2018. They hadn't picked us because they still were playing the field. So if they had known they wanted 77 to 79, I'm sure they would have played the case. They would have made a different record, I assume, because they don't have it here. And I would just say there's consequences to how you play the game. If you're looking to play, if you're waiting to play the field and you don't want to decide until the last minute to hear December 2018, this case was already I think it was filed in 2005. They hadn't picked a coverage year until then. So this is the consequence. They cannot prove the medical testimony, and then they cannot prove that each of these claimants had a significant, even if you accept the court's ruling, they admit there's not a significant occupational exposure for each of these claimants.
Counsel, you should wrap up.
Okay, on the last 2 points, I will just make 1 point on each, if that's okay.
Very brief.
Okay.
Time is up.
Okay, I'll just rest on my papers on those. I think they are largely based on policy language and clear New York law. They are strong arguments, so I don't want you to think
The case has been well briefed.
Yes, okay, fair enough. Thank you very much.
Thank you.
Well, I guess we're in the afternoon. So good afternoon, Your Honors. My name is Timothy Grassel, and I'm representing the respondents, Carrier and Elliott, in this case. Carrier and Elliott have been sued by more than 30,000 asbestos product liability tort claimants. To defend and settle those lawsuits, they've paid more than $318 million. In this case, they seek a mere $15 million from Fireman's Fund. After 3 trials and more than a decade of litigation, the trial court entered a judgment awarding Carrier and Elliott the full $15 million that they requested. Fireman's Fund has appealed a raft of issues, multiple on the trigger of coverage, the loss payable, and the defense cost ruling. I'm going to just give a very quick overview of those issues, and then I'll come back and deal with the ones that we've talked about here and any questions, of course, that Your Honors have. On the trigger issue, there are 3 separate and independent reasons that this court should affirm what the trial court has ruled. The first reason is factual. The trial court found after trial that injury in fact from asbestos begins at first occupational exposure, and that injury continues from first exposure until manifestation of the disease many years later. The court also found, as a matter of fact, that each of the underlying plaintiffs who is at issue in this case, the ones that we allocate to Fireman's Fund, each of those claimants had an occupational exposure that caused harm. Those are factual findings after a full trial. Those factual findings cannot be reversed unless this court reviews the evidence and finds that there is no fair interpretation that would sustain the judgment. The second reason that the trigger rulings need to be affirmed is because the trial court, this is a legal issue, the trial court correctly found that whether injury in fact has occurred should be determined based on whether a jury could reasonably find against Carrier and Elliott on the facts of the case when the case was settled. On that issue, you just heard it. She says these were all reasonable settlements. A jury could have found against Carrier and Elliott. The court said that's the standard. And the court was correct. The third issue and the third reason that the trigger ruling should be affirmed is a waiver issue. In addition to the factual issue and the legal issue, The court also found, as Your Honor pointed out, that Fireman's Fund had been told about these claims in 2011. They were asked, basically, will you commit to providing coverage when your policies are reached? They didn't commit to providing coverage. Instead, they denied coverage. They disclaimed coverage, and they did it expressly. They said, we expressly deny coverage. And so the court held as an alternative ruling, having done that, they have no right to come in years later and second guess whether these exposures were significant enough.
Well, in reply, the excess carrier indicates that it's really not an alternative ground. It's just another justification. Or you still have to provide that it's covered. That's still the burden the carrier has in the first instance.
Yeah,
is that incorrect?
Well, I'll read you what the judge found, because it's simply not true that it's not an alternative holding. It is absolutely an alternative holding. This is in the record 9052. The trial court says in their findings of fact and conclusions of law following the last trial, the 2025 trial. Further, the court holds that many trials of the type that Fireman's Fund seeks to engage in are not permitted. The court so holds for 5 separate and independent reasons. The fourth of those separate and independent reasons given by the court for holding that Fireman's Fund cannot challenge whether underlying claimants had a significant exposure was this. Fourth, the court's prior decisions prohibiting mini trials are correct and are consistent with New York law. As the court found after the 2019 trial, Fireman's Fund received notice of the underlying claims beginning in 2011. Furthermore, after receiving that notice, Fireman's Fund had the right and the opportunity to participate in the defense of those claims. Fireman's Fund chose not to do so. This court holds, consistent with New York law and with the prior decisions in this case by Justice Karolounis and Justice Hurlbut, that having made that decision, Fireman's Fund may not, years after the cases were settled, second guess whether the underlying asbestos plaintiffs' exposures were significant enough to have caused injury. That's in the record at 9053, and then the court further explains the reasoning for that separate holding at 9065 through 9067. So just moving on back to my overall summary, on the defense issue, the trial court correctly found that the policy language on which Fireman's Fund relies does not clearly and unambiguously limit defense coverage to claims for which indemnity was paid. There are multiple policy provisions that are wholly inconsistent with Fireman's Fund's interpretation of that policy language. And then the final is the loss payable issue that my colleague mentioned. And there are 2 independent reasons that the trial court's ruling on the loss payable clause should be affirmed. The first is that Carrier and Elliott satisfied the loss payable condition. And the second is that even if Carrier and Elliott did not satisfy the loss payable condition, Fireman's Fund cannot rely on that loss payable condition because Fireman's Fund, as I mentioned, expressly denied coverage. And having expressly denied coverage, they cannot then rely on a policy condition and say, oh, you didn't do what you were supposed to do. It would have been futile, and the law does not require Carrier and Elliott to engage in futile acts. So now I want to just go back to the trigger issue. On as I've said, the trial court found this was the trial court's actual holding on when asbestos causes injury. The court said, we've heard all the medical evidence, Dr. Gabrielson on behalf of Carrier and Elliott and Doctors Weil and Weitzman on behalf of Fireman's Fund. After hearing that evidence, the court concluded that Dr. Gabrielson's evidence, his testimony, best explains when asbestos causes injury. And what the court summarized Dr. Gabrielson's testimony, and the court summarized it like this. When a person is occupationally exposed to asbestos, some fibers evade the body's physical defense mechanisms and quickly reach the deep part of the lung. Those fibers almost immediately cause inflammation, cell injury or death, tissue scarring, and damage to DNA. Further, because asbestos fibers are durable and persist in the lung, many for years and some forever, the injuries caused by asbestos continue throughout a years or decades long latency period, and with respect to the underlying asbestos claimants, eventually resulted in a manifested clinical disease. That's 141 in the record. For Fireman's Fund, I think recognizing that they have a very weighty burden to overcome that factual finding, the first argument they're making is, well, as a legal matter, that subclinical injury just doesn't count. It's not injury in fact. That position cannot be reconciled with this court's 2020 decision in this same case. At that time, Fireman's Fund had appealed the trial court's finding that as a matter of law, subclinical damage is injury in fact. And reversed and said, no, there's a battle of the experts here. We need to have medical experts, medical testimony about when asbestos causes injury. If the court thought that subclinical damage was not injury in fact, the court could and should have ruled in favor of Fireman's Fund. Instead, it was remanded for a trial. It went back. It was heard before a different judge. Justice Parris had issued the summary judgment ruling, and Justice Antonacci, Justice Parris retired, and Justice Antonacci took over. So he heard the evidence, and he came to the same conclusion as Justice Parris, that as a matter of fact, not as a matter of law. The second point I want to make on this issue is just, if Fireman's Fund's position is adopted, it will upend decades of insurance coverage law and coverage for asbestos liabilities. It's long been the case, going back at least to the American Home Products case in the 1980s, that when subclinical damage is shown to have occurred in a particular context, as here, that counts as injury in fact. Case after case, both in New York and around the country, have so held. And I want to we're here to talk about the policy language and the facts and the law, but I want the court to be aware of what would happen if Fireman's Fund's position was adopted as a matter of fact for asbestos coverage. And the reality is there would be no coverage for asbestos liabilities because the insurance industry put asbestos exclusions into all of its policies starting in the mid-1980s. So you could never trigger any policy. That's, I think, why they're fighting so hard on this, is because they want to change that law and change that decades of history.
Counsel, I don't mean to get you off track. Could I ask you one question about the loss payable?
Of course.
You'd made. I know you'd covered it, and I had a question on it, and I missed it. In their answer, in the 2014 answer, that's where you've argued that they expressly denied coverage for all asbestos claims. That relieved you of the obligation to make a claim, which was ultimately made in December 2018, as your opposing counsel had indicated. That's when a substantial claim was made, and that's the burden, not strict compliance, but substantial compliance.
Right.
It also seemed to me that in the answer, the 2014 answer, that they also claimed that the policy provisions weren't complied with, including that provision, so that they had, in the 2014 answer, they said, we deny having coverage, but we also deny that you've met the condition precedent. So they sort of, to me, it looked like they claimed it alternatively. Well, wouldn't they be permitted to do that?
Well, I'm not saying offhand, I suspect they did because they probably threw the kitchen sink in, but the reality is that we didn't make a claim. We're not seeking coverage for any claims that were settled until after they denied coverage. And, all of the claims that we're seeking coverage for come post that express denial. Right. So it was after the denial. It was after we said, we're not covering these things, period, full stop. And keep in mind, though, that even before they made that express denial, we had been contacting them repeatedly and routinely for years. And basically saying, commit to providing coverage when we reach you. Will you give us that commitment? And they didn't do that. Instead, they asserted, 13 bases for why they wouldn't have to cover us, and basically said, they didn't say explicitly we're not going to do it, but they said it in effect. And then they said it expressly when we sued them.
But as an excess carrier where you need to have exhaustion, we don't know, perhaps carrier didn't know whether you're going to be exhausting the other policy. Probably had a good sense you were, based on the way it was going and the way the claims were coming in. But you don't know until there's a certain point you say, all right, we're going to exhaust these policies. We're now into the excess. And that's when it would seem that loss payable language becomes important, because it's like, well, when are you going to make the claim? Then we'll go back a year from there.
Well, I in the ordinary course, yes, that is correct. But here, again, they had denied coverage, and the trial court found that was an anticipatory breach of contract. And having breached the contract, they can't rely on those conditions anymore. That's the law. And there's case after case that says it, but even the Rod Chandra case, I think, is most directly on point, because that says an insurer can deny coverage and thereby forfeit its right to rely on conditions in an answer to a complaint. So on the trigger issue, so I've talked a little bit about the law. Subclinical injury is injury in fact. The next one that I want to just mention is counsel's contention that we didn't show that each underlying claimant had a significant exposure to asbestos. That's just simply not true. The key, the evidence on the issue was in fact entirely one-sided. Carrier and Elliott presented two witnesses, both of whom testified without dispute that the first exposure dates that they were using for our allocation were dates of first occupational or significant exposure. And the trial court found that testimony was, quote, unrebutted by testimony from any defense witness, was thorough, credible, and consistent. That's at R145.2. The court's summary of the evidence that was underlying that factual finding takes up 35 pages in the court's finding of fact. It's in 9014 through 50. So there's in fact a ton of evidence that supports the court's factual finding that each underlying claimant was exposed to enough asbestos to cause harm. That was the finding, and the court supported that. Fireman's Fund did not present even one witness in opposition to the evidence that we put on. Instead, what Fireman's Fund has sought to do is cast aspersions on the quality of the evidence that we put in. But again, the court, as fact finder, heard all of the evidence in person and concluded that the evidence clearly and convincingly showed that each underlying plaintiff in question experienced a significant exposure and was harmed. And in so finding, the trial court expressly rejected Fireman's Fund's critique of the evidence that we put on, and explained why that evidence was not sufficient or didn't, and that's in the record. There's 7 pages, 8 pages, 9037 through 45. So in these circumstances, there just really is no basis for this court to conclude that Carrier and Elliott failed to satisfy their burden of proof, which again is a mere preponderance of the evidence. The trial court thought that we went way above that and did it by clear and convincing evidence. Counsel,
your time is up, so you should begin to wrap up.
Okay. I think I've, unless you have questions, other questions, I will rest on our papers.
Terrific. Thank you, counsel. Case 400 and 401, LG 55 Doe versus Grassel. Mr. Collins, you're looking for frequent flyer points today? Is that what's going on?
Yeah, it's part of the.
All right, very good. Welcome again. Counsel, Mr. Tennant, please.
Good afternoon, Your Honors. David Tennant on behalf of the appellant and defendant, Father Joseph Grassel. And I would like to focus my argument on the issue of liability and why this court should grant a new trial in the interest of justice. Plaintiff's case was built on the categorically impermissible vouching on behalf of the plaintiff. And we know that this vouching testimony invaded the province of the jury. Why do we know this? Well, we look to the Vassatoro case, the third department case that was decided just before the trial in this matter. And the third department held in the context of the Child Victims Act case that a treating therapist cannot opine as to the credibility of the complaining witness and cannot opine as to the existence of the abuse as though it had in fact occurred. that is, again, reserved to the jury and isn't for a witness to come in and say, oh, we believe the plaintiff, or we believe the plaintiff was in fact abused. The Vassatore decision relies upon People versus Taylor, which is a New York Court of Appeals case, which decided the admissibility in the context of the rape trauma syndrome. And as there's also a couple of other cases that are relevant to understanding Vassatore. One is the Mercado decision in the Third Department, and also this court's decision in People versus Young, a 2022 decision, which dealt with the child abuse accommodation syndrome. And again, the teachings of all these cases is that it is impermissible for a witness to come in and vouch for the credibility of another witness, in particular, the complaining witness, and that there is no right to come in and vouch for the fact that the abuse occurred.
And so your argument is that's what the law is, and that happened in this case. Where did that happen in this case?
Well,
the vouching.
The vouching happened in through nurse practitioner Anderson Boucher's testimony, which went to as far as to say specifically, I believe him when he says he was abused by Father Grassel. And you have...
And that had to do with his treatment of this plaintiff, right? I mean, how he would treat the plaintiff and how he did treat the plaintiff thereafter.
Well, the treating therapist is not permitted to say, I believe, I am crediting his testimony when he says he was abused by Father Grassel. It's not even that she was saying his presentation of symptoms was consistent with someone who'd been sexually abused. She's saying...
You're saying it's a step further than that. It's actually saying, I believe that this actually happened. And that's where you said that's impermissible.
Right. And this actually happened, and Father Grassel is the one who actually did it. And that's also the testimony from the retained psychologist, Keller, who said that he basically was tying all of the behaviors that the plaintiff was exhibiting and saying, I attribute them, in my professional opinion, to the sexual abuse committed by Father Grassel.
When this occurs at trial, is there an objection? And what's the court's response to the objection?
No, and this is where we're left to ask the court, in the interest of justice, to order a new trial, because there was no contemporaneous objection. And in fact, the record shows that there were in limine motions, and the in limine motion didn't address the Vassatore decision and its very clear articulation of the anti-vouching rule in a Child Victims Act case.
One of the difficulties, counsel, is I think you'll quickly agree with, is for an attorney to not make an objection in a known area of law and allow something in that is, let's say, clearly appealable. Are they building in appeal in the record and doing it intentionally, and so that they can get a reversal on argument on appeal? And isn't the judge, shouldn't the judge be given an opportunity to make the correction or do a charge to the jury or make some accommodation? And isn't that the reason why it's so important to have the objection?
Of course, timely objections are what is good practice. It's what every good trial attorney is trained to do. And here it didn't happen. And the question is, what is the remedy, if any, for Father Grassel, who's had his reputation destroyed? He's, personally vilified as a child abuser for the rest of his life, because the Vassatore decision wasn't raised by the parties or the court. It came down right on the precipice of the trial. And had Vassatore been applied at trial, it would have been vastly different.
But the case itself, that can't really matter. It's the principles that matter. And those principles have been around for a long time, okay? So the fact that now the third department, a little bit before this trial, comes up with, you know, a decision encapsulating those issues, is counsel excused from raising the principles?
No, and obviously the attorneys in the Vassauteur decision itself, they were able to articulate grounds that then gave rise to the Vassauteur decision. It isn't out of whole cloth, but it is something that was a dramatic clarification in the Child Victims Act context that said these principles apply. And it's not necessarily clear about when these principles do and don't apply. For example, in Family Court Act cases, the anti-vouching rule doesn't apply because of the particular interests of children victims in family court proceedings. But that's different, you know, in criminal cases, and it's kind of what would the rule be in a Child Victims Act case? And certainly, if I had been trying the case, I certainly hope that I would have been in a position to anticipate Vassauteur, but the fact of the matter is it wasn't anticipated, and it came down 4 days before trial, after the in limine motion had been briefed and decided. So it's basically in a position where there isn't anything for the court and the parties to do at the trial. And we raised it at the first opportunity in a 4404 motion. So, I mean, it's the law. It should have been applied by the trial judge in the 4404B context as a nisi prius court, as the trial court that is obligated to apply department authority even outside the fourth department. And, you know, we're at a point where we know that the trial would have been vastly different if Vassauteur had been decided just a little bit earlier and had been cited by Father Grasso's lawyers. The trial would have been fundamentally different. And the question for this court is, given the consequences to Father Grasso and the ability of this court to grant a new trial that would actually provide the safeguards, the guardrails that would keep out this grossly vouching testimony that is incredibly damaging. It's devastating in a he said, she said trial that's going back 20 years to an unwitnessed event, and to say, okay, we're going to have these two experts come in and vouch for the plaintiff at the same time precluding Father Grasso's expert from testifying because he was unavailable and wanted to testify remotely by two-way Zoom. And he was not allowed to do that. So there wasn't even an even playing field. And when, you know, a jury is left with the unrebutted, uncontroverted testimony, that's again what plaintiff's counsel said in closing argument. This was unrebutted, uncontroverted testimony from his treating therapist and from the expert psychologist. And that obviously leaves the jury with no basis to disbelieve anything because they don't even have a contrary argument that's being presented. So it's just an opportunity. This was a fundamental error that prevented the proper consideration of his liability and materially affected the outcome of the case. And those are the talismanic the sentences that invoke the court's in justice jurisdiction. And we certainly ask that this court, in its obligation to determine what is fair and appropriate, that the court do grant a new trial in the interest of justice.
Thank you, counsel.
Good afternoon, Your Honors. As in his pre or post-trial motion, defendant raises before this court an array of arguments as to why the verdict should be set aside. None, I submit, has merit either individually or collectively. Supreme Court did not err in conducting a unified trial addressing liability, compensatory damages, and punitive damages, nor did it err in its pretrial and trial rulings, or in granting plaintiff's motion to correct the verdict and denying defendant's post-trial motion to set aside the verdict. As to the supposed impact of Vassaturo and the court's allowance of the testimony of Dr. Keller and plaintiff's treating therapist, defendant made a pretrial motion to bifurcate the trial on a very limited ground. He just wanted to keep out testimony of the expert economist and a retired police officer who would testify as to damages based upon the plaintiff's lost employment. Defendant, having been served with the expert disclosure regarding the therapist, Eve Anderson-Boucher, and the expert, Dr. Keller, objected to only one facet of their testimony, which was spelled out in the disclosure, which is the plaintiff's employment prospects. Supreme Court, in moving to bifurcate, defendant expressly stated he did not seek to preclude the testimony of any witnesses, including the treating psychiatric nurse practitioner or the expert psychologist, stating they would not have to be recalled at the damages phase. Supreme Court denied the bifurcation motion, finding that the issues of liability and damages were intertwined and there would be no simplification of the issues. Then at trial, the therapist and expert testified wholly in accordance with what their expert testimony was, stated to be in the expert disclosure. They testified, as counsel now acknowledges, without objection. Then only in the post-trial motion did defendants argue that Eve Anderson-Boucher and Dr. Keller should never have been permitted to set foot in the courtroom at the liability phase. And in arguing, defense counsel candidly admitted at page 3173.27 of the record that she was raising entirely new arguments as to why bifurcation was warranted and why the testimony was supposedly prejudicial. In the sound of exercise of its discretion, Supreme Court denied the post-trial motion, stating strategy, tactics, and choice of arguments are the province of counsel. There was no error in this case where defendant failed to raise the specter of prejudice if Ms. Anderson-Boucher and Dr. Keller were allowed to testify. And quote, defendant did not seek to limit or preclude the testimony he now finds objectionable. As I noted, or rather as stated in the expert disclosure, the treating nurse practitioner and Dr. Keller, according to the expert disclosure would testify that the sexual abuse by Joseph Grassel, the defendant, was a substantial problem in causing plaintiff's mental health problems. Now, counsel, who was not involved in the trial, now comes and says, well, it was highly prejudicial for the defense counsel to have acted in that way. But as the trial court said, they are the ones who made tactical choices. And having made those tactical choices, it would be extremely prejudicial to plaintiff to have to go through another trial where it was conducted in the manner spelled out in the jury charge, in the verdict sheet, in the pretrial expert disclosure, and unobjected to throughout the entire course of the trial. There's simply, I submit, no valid basis to come in and just say, in the interest of justice, let's have a do-over. As to a few of the other, pardon me.
You need some water, Council?
I have it right here. You have to unmute myself. On the issue of punitive damages, an argument was made that they should have been presented to the jury separately, but the presentation of them in a unified, unitary manner was set forth in the request to charge and in the verdict sheet. According to the court's pretrial order from 6 months before the trial date, objections were to be made 7 days before trial if there was any objections as to any facet of that charge or the verdict sheet, and nothing was said about conducting punitive damages trial in the manner that it was conducted. Again, there was a waiver, and I do note that obviously this court is aware of the identity of the trial counsel, and they are, competent, well-regarded, I understand, in the Rochester area. Again, they made choices on behalf of their client, and the trial was conducted in accordance with those choices. And there's no reason to basically tell plaintiff, sorry, you've got to do it over again. On the issue of the motion to correct the verdict, the court, I submit, properly granted plaintiff's motion to correct the verdict insofar as it involved the awards for future pain and suffering, which the jury awarded $50,000 over 20 years, and future healthcare, $10,000 over 20 years. Immediately after the trial, after the jury was discharged, we're still in the jury room. The judge apparently came in, thanked them for their service, and one of the jurors said, I think we made a mistake in the way that was calculated, or rather, not in the way it was calculated, in the way it was reported. That same juror later that night, after midnight, sent an email to the court reiterating there was a mistake. The court advised counsel, and every juror unanimously stated, yes, it should have been, $1 million award for pain and suffering, not $50,000. It was 50,000 times 20 years, not over 20 years. As in this court's decision in Butterfield v. Caputo, the jurors didn't impeach their verdict, but instead unanimously corrected an honest mistake that they had made in reporting it. And then briefly on the issue of supposed prejudice arising from the court's refusal to let defendant's expert neuropsychologist testify remotely. As the court pointed out in denying that, virtual testimony is permitted only under exceptional circumstances. Here, there was a day certain trial scheduled back in September 2023. 6 months later, several days before trial, defendant moved to let the expert testify remotely to accommodate some time he was spending down in Florida. And the court found the witnesses being on vacation with some vague business obligations is in no way exceptional, and it's not a necessity. It is an important witness, and it's not fair to plaintiff if he testifies via Zoom. That, I submit, was a sound exercise of discretion. As to the other points involving damages, unless the court has questions, I will rely upon the points in my brief.
Counsel, thank you.
Thank you.